Namaskar, brothers and sisters, ladies and gentlemen, students, scholars, teachers, trainers, professors, professionals, officer, officials, listeners, learners. I welcome all respected doctors and directors. I welcome honorable minister managers. I welcome adorable advocates, advertisers, and district advisors. I welcome the most honorable President Ganesh Modi. It is very nice time, nice place, nice section. Today we are appreciating our holy Indian cultural, social, spiritual, constitutional identities in the form of unity and diversity. माता शक्ति की मजबूती, सरकार का संकल्प, संविधान 131वां संशोधन बिल 2026 प्रस्ताव, लोकसभा 850 सीट का प्रस्ताव, 815 राज्य प्लस 35 केंद्र शासित प्रदेश प्रस्ताव, जनसंख्या की नई परिभाषा, यूटी कानून संशोधन बिल 2026 प्रस्ताव, महिला आरक्षण नियम लागू होंगे, क्या है प्रस्ताव 2011 की जनगणना के आधार पर सीट बंटवारा परिसीमन, संसद में परिसीमन, महिला आरक्षण से संबंधित संविधान संशोधन विधेयक पर चर्चा, मातृ शक्ति लोकसभा में चर्चा जारी, कल शाम होगी वोटिंग, महिला आरक्षण महिलाओं का अधिकार, पीएम से निर्णय लेने में नारी शक्ति को शामिल करना विकसित भारत के निर्माण पिता है। परिसीमन प्रक्रिया में किसी के साथ कोई अन्याय नहीं होगा, चाहे उत्तर हो या दक्षिण, सभी के साथ न्याय होगा। पीएम से ऑस्ट्रिया के संघीय चांसलर क्रिश्चियन स्टोकर भारत दौरे पर, ऑस्ट्रिया के संघीय चांसलर ने की पीएम से मुलाकात, भारत ऑस्ट्रिया के बीच कई क्षेत्रों में हुए एमओयू, भारत ऑस्ट्रिया के बीच हुई प्रतिनिधिमंडल स्तर की वार्ता, ऑस्ट्रिया चांसलर की यात्रा ट्रेड निवेश में नई ऊर्जा लाएगा, पीएम से। आप पूरा विश्व तनावपूर्ण। भारत ऑस्ट्रिया साझेदारी और नवाचार केंद्रित होगी। महिला आरक्षण के लिए 3 बिल पर चर्चा जारी। दोनों नेताओं ने पश्चिम एशिया के मुद्दे पर की चर्चा। MEA भारत ऑस्ट्रिया के बीच रक्षा सहयोग और सैन्य तकनीक साझेदारी। आतंकवाद रोधी संयुक्त कार्य समूह गठन पर सहमति। मातृशक्ति राष्ट्र निर्माण ऑडियो विजुअल। महिला आरक्षण के लिए 3 बिल पर चर्चा जारी। नारी बंधन पीएम की बड़ी बात है। ये निर्णय प्रक्रिया किसी के साथ अन्याय नहीं करेगी। आज के कई राज्यों में जनगणना के पहले चरण की शुरुआत। परिसीमन में किसी के साथ भेदभाव नहीं, ये मेरी गारंटी, मेरा वादा। पीएम से राष्ट्र के रूप में विचार करना हमारा दायित्व। लोकसभा में महिला आरक्षण बिल लोकसभा में पेश हुआ। 131वां संविधान संशोधन विधेयक। नियत साफ है तो शब्दों का खेल करने की जरूरत नहीं। मातृशक्ति की मजबूती सरकार का संकल्प। लोकसभा महिला आरक्षण से संबंधित संविधान संशोधन विधेयक पर चर्चा। पीएम से हम किसी भ्रम में न रहें कि हम नारी शक्ति को कुछ दे रहे हैं। यह विकास यात्रा में नया आयाम जोड़ने का अवसर। सामूहिक शक्ति से परिणाम अच्छे मिलते हैं। पीएम मोदी का संकल्प मजबूत हो मातृशक्ति। मातृशक्ति राष्ट्र निर्माण की मजबूत आधारशिला। इसे राजनीतिक रंग देने की जरूरत नहीं। महिलाओं ने सदन को हमेशा समृद्ध किया है, चाहे उत्तर हो या दक्षिण, सभी के साथ। संसदीय लोकतंत्र के इतिहास में ऐतिहासिक पहल। ऑस्ट्रिया के संघीय चांसलर क्रिश्चियन देश की दशा और दिशा तय करने वाला बिल। ऑस्ट्रिया के संघीय चांसलर ने की पीएम से मुलाकात। बिल को किसका सपोर्ट, किसका नियत में खोट। पीएम मोदी का संकल्प मजबूत हो मातृशक्ति। ऑस्ट्रिया चांसलर की यात्रा ट्रेड निवेश में नई ऊर्जा लाएगी। पीएम से आज पूरा विश्व तनावपूर्ण स्थिति से गुजर रहा है। भारत ऑस्ट्रिया साझेदारी और नवाचार केंद्रित होगी। मातृशक्ति की मजबूती सरकार का संकल्प। हम नारी शक्ति को उनका हक दे रहे हैं। भारत ऑस्ट्रिया के बीच रक्षा सहयोग। नियत साफ है तो शब्दों की जरूरत नहीं। समय की मांग। देश की 50% जनसंख्या नीति निर्धारण का बने हिस्सा। ऑडियो विजुअल सह निर्माण समझौते से फिल्म जगत। यह विकास यात्रा में नया आयाम जोड़ने का अवसर। मातृशक्ति राष्ट्र निर्माण। लोकसभा में चर्चा जारी। कल शाम होगी वोटिंग। आज से कई राज्यों में जनगणना। इसे राजनीतिक रंग देने की जरूरत नहीं। पीएम से नारी बंधन। महिलाओं ने सदन को हमेशा समृद्ध किया है। लोकसभा में महिला आरक्षण से जुड़ा बिल पेश। लोकसभा में पेश हुआ 131वां संविधान संशोधन विधेयक। पीएम मोदी का संकल्प मजबूत हो मातृशक्ति। महिला आरक्षण से संबंधित संविधान संशोधन विधेयक पर चर्चा। हम किसी भ्रम में न रहे कि हम नारी शक्ति को कुछ दे रहे हैं। पीएम से लोकसभा में चर्चा जारी। मातृशक्ति की मजबूती सरकार का संकल्प। परिसीमन में किसी का भेदभाव नहीं, ये मेरी गारंटी। राष्ट्र के रूप में विचार करना हमारा दायित्व है। पीएम से परिसीमन प्रक्रिया में किसी के साथ कोई अन्याय नहीं होगा। बिल को किसका सपोर्ट, किसकी नियत में खोट। हम नारी शक्ति को उनका हक दे रहे हैं, चाहे उत्तर हो या दक्षिण। पीएम से ऑस्ट्रिया के संघीय चांसलर क्रिश्चियन स्टोफर भारत दौरे पर। ऑस्ट्रिया के संघीय चांसलर ने की पीएम से मुलाकात। The union and its territory. Name and territory of the union, India, that is Bharat, shall be a union of states. The states and the territories thereof shall be as specified In the first schedule, the territory of India shall comprise the territories of the states, the union territories specified in the first schedule, and such other territories as may be acquired. Admission or establishment of new states. Parliament may be no admit into the union or establish new states on such terms and conditions as it thinks fit. To a Sikkim to be associated with the union represented by the Constitution 36th Amendment Act 1975 Section 5. Formation of new states and alteration of areas, boundaries or names of existing states. Parliament may, by law, form a new state by separation of territory from any state or by uniting two or more states or parts of states or by uniting any territory to a part of any state. Increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state, provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President and unless where the proposal contained in the bill affects the area, boundaries, or names of any of the states. The bill has been referred by the President to the legislature of the state for expressing its views thereon within such period as may be specified in the reference or within such further period as the President may allow and the period so specified or allowed has expired. Explanation 1 says in this article in clause A to E, state includes a union territory but in the proviso, state does not include a union territory. Explanation number 2 says the power conferred on Parliament by clause A includes the power to form a new state or union territory by uniting a part of any state or union territory to any other state or union territory. Laws made under Article 2 and 3 to provide for the amendment of the first and the fourth schedules and supplemental, incidental, and consequential matters. Any law referred to in Article 2 or Article 3 shall contain such provisions for the amendment of the first schedule and the fourth schedule as may be necessary to give effect to the provisions of the law and may also contain such supplemental, incidental, and consequential provisions, including provisions as to representation in Parliament and in the legislature or legislatures of the state or states affected by such law, as Parliament may deem necessary. No such law as aforesaid shall be deemed to be an amendment of this Constitution for the purpose of Article 368. Citizenship. Citizenship at the commencement of the Constitution. At the commencement of this Constitution, every person who has his domicile in the territory of India and who was born in the territory of India or either of whose parents was born in the territory of India or who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement shall be a citizen of India. Rights of citizenship of certain persons who have migrated to India from Pakistan. Notwithstanding anything in Article 5, a person who has migrated to the territory of India from the territory now included in Pakistan shall be deemed to be a citizen of India at the commencement of this constitution if he or either of his parents or any of his grandparents was born in India as defined in the Government of India Act 1935 as originally enacted, and the case in the case where such person has so migrated before the 19th day of July 1948, he has been ordinarily resident in the territory of India since the date of his migration, or in the case where such person has so migrated on or after the 19th day of July 1948, he has been registered as a citizen of India by an officer appointed in that behalf by the government of the Dominion of India on an application made by him thereof. Therefore, such officer, before the commencement of this constitution in the form and manner prescribed by that government, provided that no person shall be so registered unless he has been resident in the territory of India for at least 6 months immediately preceding the date of his application. Rights of citizenship of certain migrants to Pakistan. Notwithstanding anything in Article 5 and 6, a person who has after the first day of March 1947 migrated from the territory of India to the territory now included in Pakistan shall not be deemed to be a citizen of India, provided that nothing in this article shall apply to a person who, after having so migrated to the territory now included in Pakistan, has returned to the territory of India under a permit for resettlement or permanent return issued by or under the authority of any law, and every such person shall, for the purposes of Clause B of Article 6, be deemed to have migrated to the territory of India after the 19th day of July 1948. Rights of citizenship of certain persons of Indian origin residing outside India. Notwithstanding anything in Article 5, any person who either of whose parents or any of whose grandparents were born in India as defined in the Government of India Act 1935 as originally enacted, and who is ordinarily residing in any country outside India as so defined shall be deemed to be a citizen of India if he has been registered as a citizen of India by the diplomatic or consular representative of India in the country where he is for the time being residing on an application made by him thereof to such diplomatic or consular representative, whether before or after the commencement of this constitution, in the form and manner prescribed by the government of the Dominion of India or the government of India. Person voluntarily acquiring citizenship of a foreign state not to be citizens. No person shall be a citizen of India by virtue of Article 5 or be deemed to be a citizen of India by virtue of Article 6 or Article 8 if he has voluntarily acquired the citizenship of any foreign state. Continuance of the rights of citizenship. Every person who is or is deemed to be a citizen of India by virtue of Article 6 or Article 8, if he has voluntarily acquired the citizenship of any foreign state, Continuance of the rights of citizenship. Every person who is or is deemed to be a citizen of India under any of the foregoing provisions of this part shall, subject to the provisions of any law that may be made by Parliament, continue to be such citizen. Parliament to regulate the rights of citizenship by law. Nothing in the form, nothing in the foregoing provisions of this part shall derogate from the power of Parliament to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Fundamental rights. What's the definition of fundamental rights? In this part, unless generally in this part, unless the context otherwise requires, the state includes the government and parliament of India and the government and the legislature of each of the states and all local or other authorities within the territory of India or under the control of the government of India, laws inconsistent with or in derogation of the fundamental rights, all laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. In this article, unless the context otherwise requires, law includes any ordinance, order by law, rule, regulation, notification, custom, or usage having in the territory of India the force of law. Laws in force includes laws passed or made by a legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may or may not then in operation either at all or in particular areas. Nothing in this article shall apply to any amendment of this constitution made under Article 368. Right to equality, equality before law. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. No citizen shall, on grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment, or the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of the general public. Nothing in this article shall prevent the state from making any special provision for women and children. Nothing in this article or in clause 2 of the article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and the scheduled tribes. Nothing in this article or in sub clause of Article 19 shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste or the scheduled tribes insofar as such special provisions relate to their admission to educational institutions, including private educational institutions, whether added or unaided by the state, whether added or unaided by the state, other than the minority educational institutions referred to in Clause 1 of the Article 30. Equality of opportunity in matters of public employment. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any officer, to any office under the state. No citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them, be ineligible for or discriminated against in respect of any employment or office under the state. Nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government of or any local or other authority within a state or union territory, any requirement as to residence within that state or union territory prior to such employment or appointment. Nothing in this article shall prevent the state from making any provision for the preservation of appointments or posts in favor of any backward class of citizens which, in the opinion of the state, is not adequately represented in the services under the state. Nothing in this article shall prevent the state from making any provision for reservation in matters of promotion with consequential seniority to any class or classes of post in the services under the state in favor of the scheduled caste and scheduled tribes which, in the opinion of the state, are not adequately represented in the service under the state. For we, nothing in this article shall prevent the state from considering any unfilled vacancies of a year which are reserved for being filled up in that year in accordance with any provision for reservation made under clause 4 or clause for age and separate class of vacancies to be filled up in any succeeding year or year, and such class of vacancies shall not be considered together with the vacancies of the year in which they are being filled up for determining the ceiling of 50% reservation on total number of vacancies of this year. Nothing in this article shall affect the operation of any law which provides that the incumbent of an office in connection with the affairs of any religious or denomination, institution, or any member of the governing body thereof shall be person professing a particular religion or belonging to a particular denomination. Abolition of untouchability. Untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. Abolition of titles. No title, not being a military or academic distinction, shall be conferred by the state. No citizen of India shall accept any title from any foreign state. No person who is not a citizen of India shall, while he holds any office of profit or trust under the state, accept without the consent of the president any title from any foreign state. No person holding any office of profit or trust under the state shall, without the consent of the president, accept any present emolument or office of any kind from or under any foreign state. Right to freedom. Protection of certain rights regarding freedom of speech, etc. All citizens shall have the right to freedom of speech and expression, to assemble peaceably and without arms, to form associations or unions, to move freely throughout the territory of India, to reside and settle in any part of the territory of India, and to practice any profession or to carry on any occupation, trade, or business. Nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law. Insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said sub-clause in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense. Nothing in subclause B of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interest of the sovereignty and integrity of India or public order reasonable restrictions on the exercise of the right conferred by the said subclause. Nothing in subclause C of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interest of the sovereignty and integrity of India or public order or morality reasonable restrictions on the exercise of any right conferred by the said subclause. Nothing in subclauses D and E of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing reasonable restrictions on the exercise of any of the rights conferred by the said sub-clauses either in the interest of the general public or for the protection of the interest of any scheduled tribe. Nothing in sub-clause Z of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interest of the general public reasonable restrictions on the exercise of the right conferred by the said sub-clause, and in particular nothing in the sub-clause shall affect the operation of any existing law insofar as it relates to or prevent the state from making any law relating to the profession or technical qualifications necessary for practicing any profession or carrying on any occupation, trade or business or the carrying on by the state or by a corporation owned or controlled by the state of any trade, business, industry or service, whether to the exclusion, complete or partial of citizens or otherwise, protection in respect of conviction for offences. No person shall be convicted of any offence except for violation of a law enforced at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law enforced at the time of the commission of the offence. No person shall be prosecuted and punished for the same offence more than once. No person accused of any offence shall be compelled to be a witness against himself. Protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. 21A. Right to education. The state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. 22. Protection against arrest and detention in certain cases. 1 in no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest for nor shall be nor shall he deny the right to consult and to be defended by a legal practitioner of his choice. Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in custody beyond the shared period without the authority of the magistrate. Nothing in clause 1 and 2 shall apply to any person who for the time being is an enemy, alien, or to any person who is arrested or detained under any law providing for preventive detention. No law providing for preventive detention shall authorize the detention of a person for a long period than 3 months unless an advisory board consisting of persons who are or have been or are qualified to be appointed as judges of a high court has reported before the expiration of the said period of 3 months that there is in its opinion sufficient point for such detention, provided that nothing in this subclause shall authorize the detention of any person beyond the maximum period prescribed by any law made by Parliament under subclause B of clause 7, or such person is detained in accordance with the provisions of any law made by Parliament under subclause A and B of clause 7. When any person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order shall, as soon as may be, communicate to such person the grounds on which the order has been made and shall afford him the earliest opportunity of making a representation against the order. Nothing in clause 5 shall require the authority making any such order as is referred to in that clause to disclose facts which such authority considers to be against the public interest to disclose. Parliament may by law prescribe the circumstances under which and the class or classes of cases in which a person may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of an advisory board in accordance with the provisions of subclause A of clause 4. The maximum period for which any person may in any class or classes of cases be detained under any law providing for preventive detention and the procedure to be followed by an advisory board in an inquiry under subclause A of the clause 4. Right against exploitation. Prohibition of traffic in human beings and forced labor. Traffic in human beings and begar and other similar forms of forced labor are prohibited, and any contravention of this provision shall be an offence punishable in accordance with law. Nothing in this article shall prevent the state from imposing compulsory service for public purposes, and in imposing such service the state shall not make any discrimination on grounds only of religion, race, caste or class or any of them. Prohibition of employment of children in factories, etc. No child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. Right to freedom of religion. Freedom of conscience and free profession, practice and propagation of religion. Subject to public order, morality and health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law, regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice, providing for social welfare and reform of the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Explanation 1 says, the wearing and carrying of kirpans shall be deemed to be included in the profession of the Sikh religion. Explanation number 2 says, in subclause B of clause 2, the reference to Hindus shall be construed as including a reference to person professing the Sikh, Jaina, or Buddhist religion, and the reference to Hindu religions, institutions shall be construed accordingly. Freedom to manage religious affairs, subject to public order, morality, and health. Every religious denomination or any section thereof shall have the right to establish and maintain institutions for religious and charitable purposes, to manage its own affairs in matters of religion, to own and acquire movable and immovable property, and to administer such property in accordance with law. Freedom as to payment of taxes for promotion of any particular religion. No person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. Freedom as to attendance at religious instruction or religious worship in certain educational institution. No religious institution, no religious instruction shall be provided in any educational institution wholly maintained out of state funds. Nothing in clause 1 shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution. No person attending any educational institution recognized by the state or receiving aid out of state funds shall be required to take part in any religious instruction that may be imparted in such institution or to attend any religious worship that may be conducted in such institution or in any premises attached thereto unless such person or if such person is a minor, his guardian has given his consent thereto. Protection of interest of minorities, cultural and educational rights, protection of interest of minorities. Any section of the citizens residing in the territory of India or any part of thereof having a distinct language, script or culture of its own shall have the right to preserve the same. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, language, or any of them. Right of minorities to establish and administer educational institution. All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. In making any law providing for the compulsory acquisition of any property of an educational institution established and administered by a minority referred to in clause 1, the state shall ensure that the amount fixed by or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right guaranteed under that clause. The state shall not, in granting aid to educational institution, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. Compulsory acquisition of property represented by the Constitution 44th Amendment Act 1978, Section 6, WEF 26, 1979, saving of certain laws. Saving of laws providing for the acquisition of estates, etc. Notwithstanding anything contained in Article 13, no law providing for the acquisition by the state of any state or of any rights therein or the establishment of or modification of any such rights or the taking over of the management of any property by the state for a limited period either in the public interest or in order to secure the proper management of the property or the amalgamation of two or more corporations either in the public interest or in order to secure the proper management of any of the corporations or the extinguishment or modification of any rights of managing agents, secretaries and treasurers, managing directors or managers of corporation, or of any voting rights of shareholders thereof, or the extinguishment or modification of any rights accruing by virtue of any agreement, deed or license for the purpose of searching for or winning any minerals or mineral oil, or the premature termination or cancellation of any such agreement, lease or license shall be shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or Article 19, provided that where such law is a law made by the legislature of a state, the provisions of this article shall not apply thereto unless such law, having been reserved for the consideration of the President, has received his assent. Provided further that where any law makes any provision for the acquisition of by the state of any state, and where any land comprised therein is held by a person under his personal cultivation, it shall not be lawful for the state to acquire any proportion of such land as is within the ceiling limit applicable to him under any law for the time being in force for any building or structure standing thereon or appurtenant thereto, unless the law relating to the acquisition of such land, building, or structure provides for payment of compensation at a rate which shall not be less than the market value of therefore. In this article, in this article, the expression state shall in relation to any local area have the same meaning as that expression or its local equivalent has in the existing law relating to land tenures in force in that area, then shall also include any jagir, inam, inam or muafi or other similar grant, and in the states of Tamil Nadu and Kerala, any janmam right, janmam right, any land held under Rayatwari settlement, any land held or let for purposes of agriculture or for purpose ancillary thereto, including wasteland, forest land, land for pasture, or sites of buildings and other structure occupied by cultivators of land, agricultural laborers, and village artisans. The expression rights in relation to an estate shall include any rights vesting in a proprietor, sub-proprietor, under-proprietor, tenant holder, rayat under rayat or other intermediary, and any rights or privileges in respect of land revenue. Validation of certain acts and regulations without prejudice to the generality of the provisions contained in Article 31A. None of the acts and regulations specified in the ninth schedule, nor any of the provisions thereof, shall be deemed to be void or ever to have become void on the ground that such act, regulation, or provision is inconsistent with or takes away or abridges any of the rights conferred by any provisions of this part, and notwithstanding any judgment, decree, or order of any court or tribunal to the contrary. Each of the said acts and regulations shall, subject to the power of any competent legislature to repeal or amend it, continue in force, saving of laws, saving of laws giving effect to certain directive principles, notwithstanding anything contained in Article 13, no law giving effect to the policy of the state to securing All or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 or Article 19, and no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy, provided that where such law is made by the legislature of a state, the provisions of this article shall not apply thereto unless such law having been reserved for the consideration of the President has received his assent. Saving of laws in respect of anti-national activities represented by the Constitution 43rd Amendment Act 1977, Section 2 WEF 13 for 1978. Right to constitutional remedies. Remedies for enforcement of rights conferred by the part. The right to move the Supreme Court by appropriate proceedings from the enforcement of the rights conferred by this part is granted. The Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part, without prejudice to the powers conferred on the Supreme Court by clauses 1 and 2. Parliament may by law empower any other court to exercise within the spoken limits of its jurisdiction all or in any of the powers exercisable by the Supreme Court under clause 2. The right guaranteed by the right guaranteed by this article shall not be suspended except as otherwise provided for by this Constitution. Constitution validity of state laws not to be considered in proceedings under Article 32. Represented by the Constitution 43rd Amendment Act 1977, Section 3 WEF 13 14 1978. Power of Parliament to modify the rights conferred by this part in their application to forces, etc. Parliament may by law determine to what extent any of the rights conferred by the part shall in their application to the of the members of the armed forces or the members of the forces charged with the maintenance of public order or persons employed in any bureau or other organization established by the state for purposes of intelligence or counterintelligence or person employed in or in connection with the telecommunication system set up for the purposes of any force, bureau, or organization referred to in clauses A to C be restricted or abrogated so as to ensure the proper discharge of their duties and the maintenance of discipline among them. Restriction on rights conferred by this part while martial law is enforced in any area. Notwithstanding anything in the foregoing provisions of this part, Parliament may by law indemnify any person in the service of the Union or of a state or any other person in respect of any act done by him in connection with the maintenance or restoration of order in any area within the territory of India where martial law was enforced or validate any sentence passed, punishment inflicted, or future ordered or other act done under martial law in such area. Legislation to give effect to the provisions of this part. Notwithstanding anything in this Constitution, Parliament shall have, and the legislature of a state shall not have power to make laws with respect to any of the matters which under clause 3 of the Article 16, clause 3 of the Article 32, Article 33 and Article 34 may be provided for by law made by Parliament and for prescribing punishment for those acts which are declared to be offence under this part, and Parliament shall, as soon as may be after the commencement of this Constitution, make laws for prescribing punishment for the acts referred to in subclause 2. Any law in force immediately before the commencement of this Constitution in the territory of India with respect to any of the matter referred to in subclause 1 of the clause A or providing for punishment for any act referred to in subclause of that clause shall, subject to the terms thereof and to any adaptation and modifications that may be made therein under Article 372 continue in force until altered or repealed or amended by Parliament. Explanation in this article, the expression law in force has the same meaning as in Article 372. Directive principles of state policy. In its definition in this part, unless the context otherwise requires, the state has the same meaning as in part 3. Application of the principles contained in this part, the provisions contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. State to secure a social order for the promotion of welfare of the people. The state strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic and political shall inform all the institutions of the national life. The state shall, in particular, strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities, not only among us individuals but also among us groups of people residing in different areas or engaged in different vacancies. Certain principles of policy to be followed by the state. The state shall, in particular, direct its policy towards securing that the citizens, men and women, equally have the right to an adequate means of livelihood, that the ownership and control of the material resources of the community are so distributed as best to serve the common good, that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment, that there is equal pay or equal work for both men and women, that the health and strength of workers, men and women, and the tender age of children are not abused, and the citizens are not forced by economic necessity to enter a vocation unsuited to their age or strength, that children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. Equal justice and free legal aid. The state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or scheme or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. Organization of village panchayats. The state shall take steps to organize village panchayats and endow with them with such powers and authority as may be necessary to enable them to function as units of self-government, right to work, to education, and to public assistance in certain cases. The state shall, within the limits of its economic capacity and development, make effective provision for securing the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement, and in other cases of undeserved want. Provision for just and human conditions of work and maternity relief. The state shall make provision for securing just and human conditions of work and for maternity leave, living wages, etc. for workers. The state shall endeavor to secure by suitable legislation or economic organization or in any other way to all workers, agricultural, industrial or otherwise work, a living wages, conditions of work ensuring a decent standard of life and full enjoyment of leisure and social and cultural opportunities, and in particular the state shall endeavor to promote cottage industries on an individual or cooperative basis in rural areas. Participation of workers in management of industries. The state shall take steps by suitable legislation or in any other way to secure the participation of workers in the management of undertakings, establishments, or other organizations engaged in any industry. Uniform Civil Code for the citizens. The state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. Provision for early childhood care and education to children below the age of 6 years. The state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. Promotion of educational and economic interest of scheduled castes, scheduled tribes and other weaker sections. The state shall promote with special care the educational and economic interest of the weaker sections of the people and in particular of the scheduled caste and scheduled tribes and shall protect them from social injustice and all forms of exploitation. Duty of the state to raise the level of nutrition and the standard of living and to improve public health. The state shall regard the raising of the level of nutrition and the standard of living of its people and the improvement of public health as among its primary duties, and in particular the state shall endeavor to bring about prohibition of the consumption except for medicinal purposes of intoxicating drinks and of drugs which are injurious to health. Organization of agriculture and animal husbandry. The state shall endeavor to organize agriculture and animal husbandry on modern and scientific lines and shall, in particular, take steps for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other milch and draught cattle. Protection and improvement of environment and safeguarding of forest and wildlife. The state shall endeavor to protect and improve the environment and to safeguard the forest and wildlife of the country. Protection of monuments and places and objects of national importance. It shall be the obligation of the state to protect every monument or place or object of artistic or historic interest declared by or under law made by Parliament to be of national importance from violation, disfigurement, destruction, removal, disposal, or export, as the case may be. Separation of judiciary from executive. The state shall take steps to separate the judiciary from the executive in the public services of the state. Promotion of international peace and security. The state shall endeavors to promote international peace and security, maintain just and honorable relations between nations, foster respect for international law and treaty obligation in the dealings of organized people with one another, and encourage settlement of international disputes by arbitration. Fundamental duties. Fundamental duties. It shall be the duty of every citizen of India to abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem, to cherish and follow the noble ideals which inspired our national struggle for freedom, to applaud and protect the sovereignty, unity and integrity of India, to defend the country and render national service when called upon to do so, to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional diversity, to renounce practices derogatory to the dignity of women, to value and preserve the rich heritage of our composite culture, to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creation, to develop the scientific temper, humanism, and the spirit of inquiry and reform, to safeguard public property and to abjure violence, to strive towards excellence in all spheres of individuals and collective activity so that the nation constantly rises to higher levels of endeavor and achievement, who is a parent or guardian to provide opportunities for education to his child or as the case may be, ward between the age of 6 and 14 years. The Union, Chapter 1, the Executive, the President and the Vice President, the President and Vice President, the President of India. There shall be a President of India, executive power of the Union. The executive power of the Union shall be vested in the President and shall be exercised by him either directly or through officers subordinate to him in the accordance with his constitution. Without prejudice to the generality of the foregoing provision, the supreme command of the defense forces of the Union shall be vested in the President, and the exercise thereof shall be regulated by law. Nothing in this article shall be deemed to transfer to the President any function conferred by any existing law on the government of any state or other authority, or prevent Parliament from conferring by law functions on authorities other than the President. Election of President. The President shall be elected by the members of an electoral college consisting of the elected members of both houses of Parliament and the elected members of the legislature assemblies of the state in its explanation. In this article and in Article 55, state includes the national capital territory of Delhi and the union territory of Pondicherry. Manner of election of president as far as practicable, there shall be uniformity in the scale of representation of the different states at the election of the president for the purpose of securing such uniformity among the states, inter se as well as parity between the states as a whole and the union, the number of votes which is elected member of parliament and of the legislative assembly of each state is entitled to cast at such election shall be determined in the following manner. Every elected member of the Legislative Assembly of a state shall have as many votes as three, as there are multiple of 1000 in the quotient obtained by dividing the population of the state by the total number of the elected members of the assembly. If after taking the said multiples of 1000, the remainder is not less than 500, then the votes of each member referred to in subclause A shall be further increased by 1. Each elected member of either House of Parliament shall have such number of votes as may be obtained by dividing the total number of votes assigned to the members of the legislative assemblies of the states and under sub clause A and B by the total number of the elected members of both houses of parliament, fractions exceeding one half being counted as one and other fraction being disregarded. The election of the president shall be held in accordance with the system of proportional representation by means of the single transferable vote, and the voting at such election shall be by secret ballot. In its explanation in this article, the expression population means the population as ascertained at the last preceding census of which the relevant figures have been published, provided that the reference in this explanation to the last preceding census of which the relevant figures have been published shall until the relevant figures for the first census taken after the year 2026 have been published, being construed as a reference to the 1971 census. Term of office of President. The President shall hold office for term of 5 years from the date on which he enters upon his office, provided that the President may, by writing under his hand, address to the Vice President, resign his office. The President may, for violation of the Constitution, be removed from office by impeachment in the manner provided in Article 61. The President shall, notwithstanding the expiration of his term, continue to hold office until his successor enters upon his office. Any resignation addressed to the Vice President under Clause A of the provision to Clause 1 shall forthwith be communicated by him to the Speaker of the House of People. Eligibility for re-election. A person who holds or who has held office as President shall, subject to the other provisions of this Constitution, be eligible for re-election to that office. Qualification for election as President. No person shall be eligible for election as President unless he is a citizen of India, has completed the age of 35 years, and is qualified for election as a member of the House of the People. A person shall not be eligible for election as President if he holds any office of profit under the Government of India or the Government of any state or under any local or other authority subject to the control of any of the state governments. In its explanation, for the purposes of this article, a person shall not be deemed to hold any office of profit by reason only that he is the President or Vice President of the Union or the Governor of any state or is a minister either for the Union or for any state. Conditions of President's office. The President shall not be a member of either House of Parliament or of a House of the Legislature of any state and if a member of either House of Parliament or of a House of the Legislature of any state be elected President, he shall be deemed to have vacated his seat in that House on the date on which he entered upon his office as President. The President shall not hold any other office of profit. The President shall be entitled without payment of rent to the use of his official residences and shall be also entitled to such emoluments, allowances, and privileges as may be determined by Parliament by law and until provision in that behalf is so made, such emoluments, allowances, and privileges as are specified in the second schedule. The emoluments and allowances of the President shall not be diminished during his term of office, oath or affirmation by the President. Every President and every person acting as President or discharging the functions of the President shall, before entering upon his office, make and subscribe in the presence of the Chief Justice of India or in his absence, the senior most judge of the Supreme Court, available an oath or affirmation in the following form, that is to say, I, A.B. do swear in the name of God, or solemnly affirm that I will faithfully execute the office of President or discharge of the functions of the President of India and will, to the best of my ability, preserve, protect, and defend the Constitution and the law, and that I will devote myself to the service and well-being of the people of India. Procedure for impeachment of the President. When a President is to be impeached for violation of the Constitution, the charge shall be preferred by either House of Parliament. No such charge shall be preferred unless the proposal to prefer such charges is contained in a resolution which has been moved after at least 14 days notice in writing signed by not less than one-fourth of the total number of members of the House has been given of their intention to move the resolution, and such resolution has been passed by a majority of not less than two-thirds of the total membership of the House. When a charge has been so preferred by either House of Parliament, the other House shall investigate the charge or cause the charge to be investigated, and the President shall have the right to appear and to be represented at such investigation. If as a result of the investigation, a resolution is passed by a majority of not less than two-thirds of the total members of the House by which the charge was investigated or caused to be investigated, declaring that the charge preferred against the President has been sustained, such resolution shall have the effect of removing the President from his office as from the date on which the resolution is so passed. Time of holding election to fill vacancy in the office of President and the term of office of person elected to fill casual vacancy. An election to fill a vacancy caused by the expiration of term of office of President shall be completed before the expiration of term. An election to fill a vacancy in the office of President occurring by reason of his death, resignation, or removal, or otherwise shall be held as soon as possible after, and in no case later than 6 months from the date of occurrence of the vacancy, and the person elected to fill the vacancy shall, subject to the provisions of Article 56, be entitled to hold office for the full term of 5 years from the date on which he enters upon his office. The Vice President of India. There shall be a Vice President of India. The Vice President to be ex officio chairman of the Council of States. The Vice President shall be ex officio chairman of the Council of States and shall not hold any other office of profit, provided that during any period when the Vice President acts as President or discharge the functions of the President under the Article 65, he shall not perform the duties of the office of Chairman of the Council of States and shall not be entitled to any salary or allowance payable to the Chairman of the Council of States under Article 97. The Vice President to act as President or to discharge his functions during casual vacancy in the office or during the absence of President, in the event of the occurrence of any vacancy in the office of the President by reason of his death, resignation or removal, or otherwise the Vice President shall act as President until the date on which a new President elected in accordance with the provisions of this chapter to fill such vacancy enters upon his office. When the President is unable to discharge his function owing to absence, illness, or any other cause, the Vice President shall discharge his function until the date on which the President resumes his duty. The Vice President shall, during and in respect of the period while he is so acting as or discharging the functions of President, have all the powers and immunities of the President and be entitled to such emoluments, allowances, and privileges as may be determined by Parliament by law and until provision in that behalf is so made, such emoluments, allowances, and privileges as are specified in the second schedule. Election of Vice President. The Vice President shall be elected by the members of an electoral college consisting of the members of both houses of Parliament in accordance with system of proportional representation by means of the single transferable vote, and the voting at such election shall be by secret ballot. The Vice President shall not be a member of either House of Parliament or of a House of the Legislature of any state, and if a member of either House of Parliament or of a House of Legislature of any state be elected Vice President, he shall be deemed to have vacated his seat in that House on the date on which he enters upon his office as Vice President. No person shall be eligible for election as Vice President unless he is a citizen of India, has completed the age of 35 years, and is qualified for election as a member of the Council of States. A person shall not be eligible for election as Vice President if he holds any office of profit under the Government of India or the Government of any state or under any local or other authority subject to the control of any of the social government. In its explanation, for the purposes of this article, a person shall not be deemed to hold any office of profit by reason only that he is the President or Vice President of the Union or the government of any state or is a minister either for the Union or for any state. Term of office of Vice President. The Vice President shall hold office for a term of 5 years from the date on which he enters upon his office, provided that a Vice President may, by writing under his hand, addressed to the President, resign his office. Vice President may be removed from his office by a resolution of the Council of States passed by a majority of all them members of the Council and agreed to by the house of the people, but no resolution for the purpose of this clause, for the purpose of this clause shall be moved unless at least 14 days notice has been given of the intention to move the resolution. A vice president shall, notwithstanding the expiration of his term, continue to hold office until his successor enters upon his office. Time of holding election to fill vacancy in the office of vice president and the term of office of a person elected to fill casual vacancy. An election to fill a vacancy caused by the expiration of the term of office of vice president shall be completed before the expiration of the term. An election to fill a vacancy in the office of vice president occurring by reason of his death, resignation of removal, or otherwise shall be held as soon as possible after the occurrence of the vacancy, and the person elected to fill the vacancy shall, subject to the provisions of Article 67, be entitled to hold office for the full term of 5 years from the date on which he enters upon his office. Oath or affirmation by the Vice President. Every Vice President shall, before entering upon his office, make and subscribe before the President or some person appointed in that behalf behalf by him, an oath or affirmation in the following form, that is to say, I, A.B. do swear in the name of God. I, A.B. do solemnly affirm that I will bear true faith and allegiance to the Constitution of India as by law established, and that I will faithfully discharge the duty upon which I am about to enter. Discharge of President's function in other contingencies. Parliament may make such provisions as it thinks fit for the discharge of the function of the President in any contingency not provided for in this chapter. Matters relating to or connected with the election of a president or vice president, all doubts and disputes arising out of or in connection with the election of a president or vice president shall be inquired and decided by the Supreme Court, whose decision shall be final. If the election of a person as president or vice president is declared void by the Supreme Court, acts done by him in the exercise and performance of the powers and duties of the office of president or vice president, as the case may be, or on or before the date of the decision of the Supreme Court, shall not be invalidated by reason of that declaration. Subject to the provisions of this Constitution, Parliament may law regulate any matter relating to or connected with the election of a president or vice president. The election of a person as president or vice president shall not be called in question on the ground of the existence of any vacancy for whatever reason among the members of the electoral college electing him. Power of president to grant pardons, etc., and to suspend, remit, or commute sentences in certain cases. The president shall have the power to grant pardons, reprise, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of any person convicted of any offense in all cases where the punishment or sentence is by a court martial. In all cases where the punishment or sentence is for an offense against any law relating to a matter to which the executive powers of the Union extend. In all cases where the sentence is a sentence of death, nothing in subclause A of clause 1 shall affect the power conferred by law on any officer of the armed forces of the Union to suspend, remit, or commute a sentence passed by a court martial. Nothing in subclause of clause 1 shall affect the power to suspend, remit, or commute a sentence of death exercisable by the governor of a state under any law for the time being in force. Extent of executive power of the Union. Subject to the provisions of this Constitution, the executive power of the Union shall extend to the matters with respect to which Parliament has power to make laws and to the exercise of such rights, authority, and jurisdiction as are exercisable by the Government of India by virtue of any treaty or agreement, provided that the executive power referred to in subclause shall not, save as expressly provided in this Constitution or in any law made by Parliament, extend in any state to matters with respect to which the legislature of the state shall also power to make laws, until otherwise provided by Parliament, a state and any officer or authority of a state may, notwithstanding anything in this article, continue to exercise in matters with respect to which Parliament has power to make laws for that state such executive power or function as the state or officer or authority thereof could exercise immediately before the commencement of this Constitution. Council of Ministers. Council of Ministers to aid and advise President. There shall be a council of ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his function, act in accordance with such advice, provided that the President may require the Council of Ministers to reconsider such advice, either generally or otherwise, and the President shall act in accordance with the advice standard after such reconsideration. The question whether any, and if so what, advice was tendered by ministers to the President shall not be inquired into in any court. Other provisions as to ministers, the Prime Minister shall be appointed by the President and the other ministers shall be appointed by the President on the advice of the Prime Minister. The total number of ministers, including the Prime Minister, in the Council of Ministers shall not exceed 15% of the total number of members of the House of the People. A member of either House of Parliament belonging to any political party who is disqualified for being a member of that House under paragraph 2 of the 10th schedule shall also be disqualified to be appointed as a minister under clause 1 for duration of the period commencing from the date of his disqualification till the date on which the term of his office as such member would expire or where he contends any election to either House of Parliament before the expiry of such period till the date on which he is declared elected, whichever is easier. The minister shall hold office during the pleasure of the President. The Council of Ministers shall be collectively responsible to the House of the People. Before a minister enters upon his office, the President shall administer to him the oaths of office and of secrecy according to the form set out for the purpose in the third schedule. A minister who for any period of 6 consecutive months is not a member of either House of Parliament shall at the expiration of that period cease to be a minister. The salaries and allowances of ministers shall be such a Parliament may from time to time by law determine, and until Parliament so determines, shall be as specified in the second schedule, the Attorney General for India Attorney General for India, the President, shall appoint a person who is qualified to be appointed a judge of the Supreme Court to be Attorney General for India. It shall be the duty of the Attorney General to give advice to the Government of India upon such legal matters and to perform such other duties of a legal character as may from time to time be referred to or assigned to him by the President and to discharge the function conferred on him by or under this Constitution or any other law for the time being in force. In the performance of his duties, the Attorney General shall have right of audience in all courts in the territory of India. The Attorney General shall hold office during the pleasure of the President and shall receive such remuneration as the President may determine. Conduct of government business. Conduct of business of the Government of India. All executive action of the Government of India shall be expressed to be taken in the name of the President. Ordinance, orders, and other instruments made and executed in the name of the President shall be authenticated in such manner as may be specified in the rules to be made by the President, and the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the President. The President shall make rules for the more convenience transaction of the business of the Government of India and for the allocation among ministers of the said business. Duties of Prime Minister as respects the furnishing of information to the President, etc. It shall be the duty of the Prime Minister to communicate to the President all decisions of the Council of Ministers relating to the administration of the affairs of the Union and proposals for legislation. To furnish such information relating to the administration of the affairs of the Union and proposals for legislation as the President may call for, and if the President so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Chapter 2 Parliament Generally Parliament Constitution of Parliament. There shall be a Parliament for the Union which shall consist of the President and two houses to be known respectively as the Council of States and the House of the People. Composition of the Council of States. The Council of States shall consist of 12 members to be nominated by the President in the accordance with the provisions of Clause 3 and not more than 238 representatives of the states and of the Union territories. The allocation of seats in the Council of States to be filled by representatives of the states and of the Union territories shall be in accordance with the provisions in that behalf contained in the fourth schedule. The members to be nominated by the President under subclause A of clause shall consist of persons having special knowledge or practical experience in respect of such matters as the following, namely literature, science, art, and social service. The representatives of each state in the Council of States shall be elected by the elected members of the Legislative Assembly of the state in accordance with the system of proportional representation by means of the single transferable vote. The representatives of the Union territories in the Council of States shall be chosen in such manner as Parliament may by law prescribe. composition of the House of the People. Subject to the provisions of Article 331, the House of the People shall consist of not more than 530 members of chosen by direct election from territorial constituencies in the states and not more than 20 members to represent the union territories chosen in such manner as Parliament may by law provide for the purposes of sub-clause A of clause 1. There shall be allotted to each state a number of seats in the House of the People in such manner that the ratio between that number and the population of the state is, so far as practicable, the same for all states. And each state shall be divided into territorial constituencies in such manner that the ratio between the population of each constituency and the number of seats allotted to it is, so far as practicable, the same throughout the state, provided that the provisions of sub-clause A of this clause shall not be applicable for the purpose of allotment of seats in the House of the People to any state so long as the population of that state does not exceed 6 millions. In this article, the expression population means the population as ascertained at the last preceding census of which the relevant figures have been published, provided that the reference in this clause to the last preceding census of which the relevant figures have been published shall, until the relevant figures for the first census taken after the year 2026 have been published, be construed for the purpose of subclause A of clause and of the proviso to that clause as a reference to the 1971 census and for the purpose of subclause B of the clause as a reference to the 2001 census readjustment after each census. Upon the completion of each census, the allocation of seats in the House of People to the states and the division of each state into territorial constituencies shall be readjusted by such authority and in such manner as parliamentary may by law determine, provided that such adjustment shall not affect representation in the House of the People until the dissolution of the then existing House. Provided further provided further that such readjustment shall take effect from such date as the President may, by order, specify, and until such readjustment takes effect. Any election to the House may be held on the basis of the territorial constituency existing before such readjustment, provided also that until the relevant figures for the first census taken after the year 2026 have been published, it shall not be necessary to readjust. The allocation of seats in the House of People to the state as readjusted on the basis of the 1971 census and the division of such a state into territorial constituencies as may be readjusted on the basis of the 2001 census under this article. Duration of Houses of Parliament. The Council of States shall not be subject to dissolution, but as nearly as possible, one third of the members thereof shall retire as soon as may be on the expiration of every second year in accordance with the provisions made in that behalf by Parliament by law. The House of the People, unless sooner dissolved, shall continue for 5 years from the date appointed for its first meeting and no longer, and the expiration of the said period of 5 years shall operate as a dissolution of the House, provided that the said period may, while a proclamation of emergency is in operation, be extended by Parliament by law for a period not exceeding 1 year at a time, and not exceeding in any case beyond a period of 6 months after the proclamation has ceased to operate. Qualification for membership of Parliament. A person shall not be qualified to be chosen to fill a seat in Parliament unless he is a citizen of India and makes and subscribes before some person authorized in that behalf by the Election Commission on as an oath or affirmation according to the form set out for the purpose in the third schedule. It is in the case of a seat in the Council of State, not less than 30 years of age, and in the case of a seat in the House of the People, not less than 25 years of age, and possesses such other qualifications as may be prescribed by as may be prescribed in that behalf by or under any law made by Parliament, sessions of Parliament, prorogation and dissolution. The President shall from time to time summon each House of Parliament to meet at such time and place as he thinks fit, but 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. The President may from time to time prorogue the houses or either house, dissolve the House of the People, right of President to address and send messages to houses. The President may address either House of Parliament or both houses assembled together, and for that purpose require the attendance of members. The President may send messages to either House of Parliament, whether with respect to a bill then pending in Parliament or otherwise, and a House to which any message is so sent shall with all convenient dispatch consider any matter required by the message to be taken into consideration. Special address by the President. At the commencement of the first session of each general election to the House of the People and at the commencement of the first session of each year, the President shall address both Houses of Parliament assembled together and inform Parliament of the causes of its summon. Provisions shall be made by the rules regulating the procedure of either House for the allotment of time for discussion of the matters referred to in such address. Rights of Ministers and Attorney General as respect Houses. Every Minister and the Attorney General of India shall have the right to speak in and otherwise to take part in proceedings of either House, any joint sitting of the Houses, and any committee of Parliament of which he may be named a member, but shall not by virtue of this article be entitled to what? Officers of Parliament, the Chairman and Deputy Chairman of the Council of State. The Vice President of India shall be ex officio Chairman of the Council of State. The Council of State shall, as soon as may be, choose a member of the Council to be Deputy Chairman thereof, and so often as the office of Deputy Chairman becomes vacant, the Council shall choose another member to be Deputy Chairman thereof. Vacation and resignation of and removal from the office of Deputy Chairman. A member holding office as Deputy Chairman of the Council of State shall vacate his office if he ceases to be a member of the Council. May at any time by writing under his hand addressed to the chairman resign his office and may be removed from his office by a resolution of the council passed by a majority of all the then members of the council, provided that no resolution for the purpose of clause shall be moved unless at least 14 days notice has been given of the intention to move the resolution. Power of the deputy chairman or other person to perform the duties of the office of or to act as chairman while the office of chairman is vacant or during any period of or during any period when the vice president is acting as or discharging the functions of president, the duties of the office shall be performed by the deputy chairman, or if the office of deputy chairman is also vacant, by such member of the council of states as the president may appoint for the purpose during the absence of the chairman from any sitting of the Council of States, the Deputy Chairman, or if he is also absent, such person as may be determined by the rules of procedure of the Council, or if no such person is present, such other person as may be determined by the Council shall act as Chairman. The Chairman or the Deputy Chairman not to preside while a resolution for his removal from office is under consideration at any sitting of the Council of States, while any resolution for the removal of the Vice President from his office is under consideration. The Chairman, or while any resolution for the removal of the Deputy Chairman from his office is under consideration, the Deputy Chairman shall not, though he is present, preside, and the provisions of clause of Article 91 shall apply in relation to every such sitting as they apply in relation to a sitting from which the chairman or as the case may be, the deputy chairman is absent. The chairman shall have the right to speak in and otherwise to take part in the proceedings of the Council of States, while any resolution for the removal of the Vice President from his office is under consideration in the Council, but notwithstanding anything in Article 100, shall not be entitled to vote at all on such resolution or on any other matter during such proceedings. The Speaker and Deputy Speaker of the House of the People shall, as soon as may be, choose two members of the House to be respectively Speaker and Deputy Speaker thereof. And so often as the office of Speaker or Deputy Speaker becomes vacant, the House shall choose another member to be Speaker or Deputy Speaker as the case may be. Vacation and resignation of and removal from the office is of the Speaker or Deputy Speaker. A member of holding office as the Speaker or Deputy Speaker of the House of the People shall vacate his office if he ceases to be a member of the House of the People, may at any time by writing under his hand address, if such member is the speaker, to the deputy speaker, and if such member is the deputy speaker, to the speaker, resign his office, and may be removed from his office by a resolution of the House of the People passed by majority of all the then members of the House, provided that no resolution for the purpose of clause C shall be moved unless at least 14 days notice has been given of the intention to move the resolution. Provided further that whenever the House of the People is dissolved, the Speaker shall not vacate his office until immediately before the first meeting of the House of the People after the dissolution. Power of the Deputy Speaker or other person to perform the duties of the office of or to act as Speaker. While the office of Speaker is vacant, The duties of the office shall be performed by the Deputy Speaker, or if the office of Deputy Speaker is also vacant, by such member of the House of the people as the President may appoint for the purpose. During the absence of the Speaker from any sitting of the House of the people, the Deputy Speaker, or if he is also absent, such person as may be determined by the rules of procedure of the House, or if no such person is present, such other person as may be determined by the House shall act as the Speaker. The Speaker or the Deputy Speaker not to preside while a resolution for his removal from office is under consideration at any sitting of the House of the People, while any resolution for the removal of the Speaker from his office is under consideration, the Speaker, or while any resolution for the removal of the Deputy Speaker from his office is under consideration, the Deputy Speaker shall not, though he is present, resign, and the provisions of clause of Article 95 shall apply in relation to every such sitting as they apply in relation to a sitting from which the Speaker, or as the case may be, the Deputy Speaker is absent. The Speaker shall have the right to speak in and otherwise to take part in the proceedings of the House of the People while any resolution for his removal from office is under consideration in the House, and shall, notwithstanding anything in Article 100, be entitled to vote only in the first instance on such resolution or on any other matter during such proceedings, but not in the case of any of an equality of votes, salaries, and allowances of the chairman and deputy chairman and the speaker and the deputy speaker. There shall be paid to the chairman and the deputy chairman of the Council of States, and to the speaker and the deputy speaker of the House of the People, such salaries and allowances as may be respectively fixed by Parliament by law, and until provision in that behalf is so made, such salaries and allowances as are specified in the second schedule. Secretariat of Parliament. Each House of Parliament shall have a separate secretarial staff, provided that nothing in this clause shall be construed as preventing the creation of post common to both Houses of Parliament. Parliament may, by law, regulate the recruitment and the conditions of services of persons appointed to the secretarial staff of either House of Parliament. Until provision is made by Parliament under Clause 2, the President may, after consultation with the Speaker of the House of the People or the Chairman of the Council of States, as the case may be, make rules regulating the recruitment and the conditions of service of persons appointed to the secretarial staff of the House of the People or the Council of States, and any rule so made shall have effect subject to the provisions of any law made under the said clause, conduct of business, oath or affirmation by members. Every member of either House of Parliament shall, before taking his seat, make and subscribe before the President or some person appointed in that behalf by him an oath or affirmation according to the form set out for the purpose in the third schedule. Voting in houses, power of houses to act notwithstanding vacancies and quorum. Save as otherwise provided in this constitution, all questions at any sitting of either house or joint sitting of the houses shall be determined by majority of votes of the members present and voting, other than the speaker or person acting as chairman or speaker, the chairman or speaker or person acting as such shall not vote in the first as instance, but shall have and exercise a casting vote in the cause of an equality of votes. Either House or Parliament shall have power to act notwithstanding any vacancy in the membership thereof, and any proceedings in Parliament shall be valid notwithstanding that it is discovered subsequently that some person who was not entitled so to do sat or voted or otherwise took part in the proceedings. Until Parliament by law otherwise provides, the quorum to constitute a meeting of either House or Parliament shall be one-tenth of the total number of members of the House. If at any time during the meetings of a House there is no quorum, it shall be the duty of the chairman or speaker or person acting as such either to adjourn the House or to suspend the meeting until there is a quorum. Disqualification of members. Disqualification of members. Vacation of seats. No person shall be a member of both houses of Parliament, and provision shall be made by Parliament by law for the vacation by a person who is chosen a member of both houses of his seat in one house or the other. No person shall be member both of Parliament and of a house of a legislature of state. And if a person is chosen a member both of Parliament and a house of legislature of, then at the expiration of such period, as may be specified in rules made by the President, that person's seat in Parliament shall become vacant unless he had previously resigned his seat in the legislature of the state. If a member of either House of Parliament becomes subject to any of the disqualification mentioned in the clause 1 or clause 2 of Article 102, or resigns his seat by writing under his hand addressed to the chairman or the speaker, as the case may be, and his resignation is accepted by the chairman or the speaker, as the case may be, his seat shall thereupon become vacant, provided that in the case of any resignation referred to in some clause B, if from information received or otherwise, and after making such inquiry as he thinks fit, the chairman or the speaker, as the case may be, is satisfied that such resignation is not voluntary or genuine, he shall not accept such resignation. If for a period of 60 days a member of either House of Parliament is without permission of the House absent from all meetings thereof, the House may declare his seat vacant, provided that in computing the said period of 60 days, no account shall be taken of any period during which the House is prorogued or is adjourned for more than 4 consecutive days. Disqualifications for membership. A person shall be disqualified for being chosen as and for being a member of either House of Parliament if he holds an office of profit under the Government of India or the Government of any state other than an office declared by Parliament by law not to disqualify its holder. If he is of unsound mind and stands so declared by a competent court, if he is an undischarged insolvent, if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state, or is under any acknowledgement of allegiance or adherence to a foreign state, if he is so disqualified by or under any law made by Parliament, in its explanation, for the purpose of this clause, a person shall not be deemed to hold an office of profit under the Government of India or the Government of any state by reason only that he is a minister either for the Union or for such state. A person shall be disqualified for being a member of either House of Parliament if he is so qualified under the 10th schedule. Decision on question as to disqualification of members. If any question arises as to whether a member of either House of Parliament has become subject to any of the disqualifications mentioned in clause 1 of the Article 102, the question shall be referred for the decision of the President and his decision shall be final. Before giving any decision on any such question, the President shall obtain the opinion of the Election Commission and shall act according to such opinion. Penalty for sitting and voting before making oath or affirmation under Article 99 or when not qualified or when disqualified. If a person sits or votes as a member of either House of Parliament before he has complied with requirements of Article 99 or when he knows that he is not qualified or that he is disqualified for membership thereof or that he is prohibited from so doing by the provisions of any law made by Parliament, he shall be liable in respect of each day on which he so sits or votes to a penalty of 500 rupees to be recovered as a debt due to the Union. Powers, privileges, and immunities of Parliament and its members. Powers, privileges, etc. of the Houses of Parliament and of the members of the members and committees thereof, subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of Parliament, there shall be freedom of speech in Parliament. No member of Parliament shall be liable to any proceedings in any court in respect of anything said or any word given by him in Parliament or any committee thereof, and no person shall be so liable in respect of the publication by or under the authority of either Houses of Parliament of any report, paper, words or proceedings. In other respects, the powers, privileges and immunities of each House of Parliament and of the members and the committees of each House shall be such as may from time to time be defined as Parliament by law, and until so defined shall be those of that House and of its members and committees immediately before the coming into force of Section 15 of the Constitution, 44th Amendment Act 1978. The provisions of Clause 1, 2, and 3 shall apply in relation to persons who, by virtue of this Constitution, have the right to speak in and otherwise to take part in the proceedings of a House of Parliament or any committee thereof as they apply in relation to members of Parliament. Salaries and allowances of members. Members of either House of Parliament shall be entitled to receive such salaries and allowances as they may from time to time constitute administrative procedure. Provisions as to introduction and passing of bills, subject to the provisions of Article 109 and 117 with respect to money bills and other financial bills. A bill may originate in either House of Parliament, subject to the provisions of Article 108 and 9. A bill shall not be deemed to have been passed by the House of Parliament unless it has been agreed to by both houses, either without amendment or with such amendments only as are agreed to by both houses. A bill pending in Parliament shall not lapse by reason of the propagation of the House. A bill pending in the Council of States which has not been passed by the House of the people shall not lapse on a dissolution of the House of the people. A bill which is pending in the House of the people or which having been passed by the House of the people is pending in the Council of States shall, subject to the provisions of the Article 108, lapse on a dissolution of the House of the people. Joint sitting of both houses in certain cases. If after a bill has been passed by one house and transmitted to the other house, the bill is rejected by the other house, or the houses have finally disagreed as to the amendments to be made in the bill, or more than 6 months elapsed from the date of the reception of the bill by the other house without the bill being passed by it, the President may, unless the bill has elapsed by reason of a resolution of the House of the People, notify to the Houses by message if they are sitting, or by public notification if they are not sitting, his intention to summon them to meet in a joint sitting for the purpose of deliberating and voting on the bill, provided that nothing in this clause shall apply to a money bill. In reckoning any such period of 6 months as is referred to in clause 1, no account shall be taken of any period during which the House referred to in some clause of that clause is prorogued or adjourned for more than 4 consecutive days. Where the President has under clause notified his intention of summoning the Houses to meet in a joint sitting, neither House shall proceed further with the bill, but the President may at any time after the date of his notification summon the Houses to meet in a joint sitting for the purpose specified in the notification, and if he does so, the Houses shall meet accordingly. If at the joint sitting of the two Houses the bill with such amendments, if any, as are agreed to in joint sitting is passed by a majority of the total number of members of both houses present and voting, it shall be deemed for the purpose of this constitution to have been passed by both houses, provided that as provided that at a joint sitting, if the bill having been passed by one house has not been passed by the other house with amendments and returned to the house in which it originated, no amendment shall be proposed to the bill other than such amendments, if any, are as are made necessary by the delay in the passage of the bill. If the bill has been so passed and returned, only such amendments as aforesaid shall be proposed to the bill, and such other amendments as are relevant to the matters with respect to which the Houses have not agreed, and the decision of the person presiding as to the amendments which are admissible under the clause shall be final. A joint sitting may be held under this article and the bill passed thereof, notwithstanding that a resolution of the House of the People has intervened since the President notified his intention to summon the Houses to meet therein. Special procedure in respect of money bills. A money bill shall not be introduced in the Council of States. After a money bill has been passed by the House of the People, it shall be transmitted to the Council of States for its recommendation, and the Council of States shall, within a period of 14 days from the date of its receipt of the bill, return the bill to the House of the People with its recommendation, and the House of the People may thereupon either accept or reject all or any of the recommendations of the Council of States. If the House of the People accepts any of the recommendations of the Council of States, the money bill shall be deemed to have been passed by both houses with the amendments recommended by the Council of States and accepted by the House of the People. If the House of the People does not accept any of the recommendations of the Council of States, the money bill shall be deemed to have been passed by both houses in the form in which it was passed by the House of the People without any of the amendment recommended by the Council of states. If a money bill passed by the House of the People and transmitted to the Council of States for its recommendation is not returned to the House of the People within the said period of 14 days, it shall be deemed to have been passed by both houses at the expiration of the said period in the form in which it was passed by the House of the People. Definition of money bill. For the purposes of this chapter, a bill shall be deemed to be a money bill if it contains only provisions dealing with all or any of the following matters, namely the imposition, abolition, remission, alteration, or regulation of any tax, the regulation of the borrowing of money or giving of any guarantee by the Government of India, and the amendment of the law with respect to any financial obligation undertaken or to be undertaken by the Government of India, the custody of the consolidated fund or the contingency fund of India, the payment of money into or the withdrawal of money from any such fund, the appropriation of money out of the consolidated fund of India, the declaring of any expenditure to be expenditure charged on the consolidated fund of India, or the increasing of the amount of any such expenditure, the receipt of money on account of the consolidated fund of India or the public account of India, or the custody or issue of such money, or the audit of the accounts of the Union or of a state, or any matter incidental to any of the matters specified in subclause A and F. A bill shall not be deemed to be a money bill by reason only that it provides for the position of fines or other pecuniary penalties. Pecuniary penalties or for the demand or payment of fees for licenses or fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration, or regulation of any tax by any local authority or body for local purposes. If any question arises whether a bill is a money bill or not, the decision of the Speaker of the People thereon shall be final. There shall be endorsed on every money bill when it is transmitted to the Council of States under Article 109, and when it is presented to the President for assent under Article 111, the certificate of the Speaker of the House of the People signed by him that it is a money bill. Assent to bills. When a bill has been passed by the Houses of Parliament, it shall be presented to the President, and the President shall declare either that he assents to the bill or that he withholds assent therefrom, provided that the President may, as soon as possible after the presentation to him of a bill for assent, return the bill if it is not a money bill to the Houses with a message requesting that they will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendments as he may recommend in his message, and when a bill is so returned, the Houses shall reconsider the bill accordingly. And if the bill is passed again by the Houses with or without amendment and presented to the President for assent, the President shall not withhold assent therefrom. Procedure in financial matters. Annual financial statement. The President shall, in respect of every financial year, cause to be laid before both the Houses of Parliament a statement of the estimated receipt and expenditure of the Government of India for that year, in this part referred to as the annual financial statement. The estimates of expenditure embodied in the annual financial statement shall show separately the sum required to meet expenditure described by this Constitution as expenditure charged upon the consolidated fund of India, and The sums required to meet other expenditure proposed to be made from the Consolidated Fund of India and shall distinguish expenditure on revenue account from other expenditure. The following expenditure shall be expenditure charged on Consolidated Fund of India: the emoluments and allowances of the presidents and other expenditure relating to his office, the salaries and allowances of the chairman and the deputy chairman of the Council of States and the speaker and the deputy speaker of the House of the People, that charge that charges for which the government of India is liable, including interest, sinking fund charges and redemption charges, and other expenditure relating to the raising of loans and the service and redemption of debt. The salaries, allowances, and pensions payable to or in respect of judges of the Supreme Court. The pension payable to or in respect of judges of the Federal Court. The pensions payable to or in respect of judges of any High Court which exercises jurisdiction in relation to any area included in the territory of India or which at any time before the commencement of this constitution exercise jurisdiction in relation to any area included in a governor's province of the Dominion of India. The salary, allowances, and pension payable to or in respect of the Comptroller and Auditor General of India, any sums required to satisfy any judgment, decree, or award of any court or arbitral tribunal, any other expenditure declared by this Constitution by Parliament by law to be so charged. Procedure in Parliament with respect to estimates. So much of the estimates as relates to expenditure charged upon the Consolidated Fund of India shall not be submitted to the vote of Parliament, but nothing in this clause shall be construed as preventing the discussion in either House of Parliament of any of those estimates. So much of the said estimates as relates to other expenditure shall be submitted in the form of demands for grants to the House of the People, and the House of People shall have power to assent or to refuse to assent to any demand or to assent to any demand subject to a reduction of the amount specified therein. No demand for a grant shall be made except on the recommendation of the President. Appropriation bills as soon as may be after the grants under Article 113 have been made by the House of the People, there shall be introduced a bill to provide for the appropriation out of the Consolidated Fund of India of all monies required to meet the grants so made by the House of the People, and the expenditure charged on the Consolidated Fund of India, but not exceeding in any case the amount shown in the statement previously read before Parliament. No amendment shall be proposed to any such bill in either House of Parliament which will have the effect of varying the amount of altering the destination of any grant so made, or of varying the amount of any expenditure charged on the Consolidated Fund of India, and the decision of the person presiding as to whether an amendment is admissible under this clause shall be final, subject to the provisions of Article 115 and 116. No money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law passed in accordance with the provisions of this article. Supplementary, additional, or excess grants the President shall, if the amount authorized by any law made in accordance with the provisions of Article 114 to be expended for a particular service for the current financial year is found to be insufficient for the purposes of that year, or when a need has arisen during the current financial year for supplementary or additional expenditure upon some new service not contemplated in the annual financial statement for that year, or if any money has been spent on any service during a financial year in excess of the amount granted for that service, and for that year was to be laid before the Houses of Parliament. Another statement showing the estimated amount of that expenditure or cost to be presented to the House of the People, a demand for such access as the case may be. The provisions of Article 112, 113 and 114 shall have effect in relation to any such statement and expenditure or demand, and also to any law to be made authorizing the appropriation of money out of the consolidated fund of India to meet such expenditure or the grant in respect of such demand as they have effect in relation to the annual financial statement and the expenditure mentioned therein, or to a demand for a grant and the law to be made for the authorization of appropriation of money out of the consolidated fund of India to meet such expenditure or grant, votes on account, votes of credit and exceptional grants. Notwithstanding anything in the foregoing provisions of this chapter, the House of the People shall have power to make any grant in advance in respect of the estimated expenditure for a part of any financial year pending the completion of the procedure prescribed in Article 113 for the voting of such grant and passing of the law in accordance with the provisions of Article 114 in relation to that expenditure. To make a grant for meeting an unexpected demand upon the resources of India, when on account of the magnitude of the indefinite character of the service, the demand cannot be stated with the details ordinarily given in an annual financial statement. To make an exceptional grant which forms and Parliament shall have power to authorize by law the withdrawal of monies from the consolidated fund of India for the purposes for which the said grants are made. The provisions of Article 113 and 114 shall have effect in relation to the making of any grant under clause 1 and to any law to be made under that clause as they have effect in relation to making of a grant with regard to any expenditure mentioned in the annual financial statement and the law to be made for the authorization of provision of monies out of the consolidated fund of India to meet such expenditure. Special provisions as to financial bills. A bill or amendment making provision for any of the matters specified in sub-clauses A to F of clause 1 of the article 110 shall not be introduced or moved except on the recommendation of the President, and a bill making such provision shall not be introduced in the Council of States, provided that no recommendation shall be required under this clause for the moving of an amendment making provision for the reduction or abolition of any tax. A bill or amendment shall not be deemed to make provision for any of the matters aforesaid by reason only that it provides for the imposition of fines or other pecuniary penalties or for the demand or payment of fees for licenses or fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration, or regulation of any tax by any local authority or body for local purposes. A bill, if enacted and brought into operation, would involve expenditure from the Consolidated Fund of India shall not be passed by either House of Parliament unless the President has recommended to that House the consideration of the bill procedure Generally, rules of procedure. Each House of Parliament may make rules for regulating, subject to the provisions of this Constitution, its procedure and conduct of its business. Until rules are made under Clause 1, the rules of procedure and standing orders in force immediately before the commencement of this Constitution with respect to the legislature of the Dominion of India shall have effect in relation to Parliament, subject to such modification and adaptation as may be made therein by the chairman of the Council of States or by the Speaker of the House of the People as the case may be. The President, after consultation with the Chairman of the Council of States and the Speaker of the House of the People, may make rules as to the procedure with respect to joint sittings of and communications between the two houses. At a joint sitting of the two houses, the Speaker of the House of the People, or in his absence, such person as may be determined by rules of procedure made under Clause 3, shall preside. Regulation by law of procedure in Parliament in relation to financial business. Parliament may, for the purpose of the timely completion of financial business, regulate by law the procedure of and the conduct of business in each House of Parliament in relation to any financial matter or to any bill for the appropriation of money out of the Consolidated Fund of India, and if and so far as any provision of any law so made is inconsistent with any rules made by a House of Parliament under clause 1 of Article 118 or with any rule or standing order having effect in relation to Parliament under clause 2 of that article, such provision shall prevail. Language to be used in Parliament, notwithstanding anything in Part 17, but subject to the presence of Article 348. Business in Parliament shall be transacted in Hindi or in English, provided that the chairman of the Council of States or Speaker of the House of the People or person acting as such, as the case may be, may permit any member who cannot adequately express himself in Hindi or in English to address the House in his mother tongue. Unless Parliament, after the expiration of a period of 15 years from the comment, have effect as if the words, or in English, were omitted therefrom. Restriction on discussion in Parliament. No discussion shall take place in Parliament with respect to the conduct of any judge of the Supreme Court or of a High Court in the discharge of his duties except upon a motion for presenting an address to the President praying for the removal of the judge as herein after provided. Courts not to inquire into proceedings of Parliament. The validity of any proceeding in Parliament shall not be called in question on the ground of any alleged irregularity of procedure. No officer or member of Parliament in whom powers are vested or by under this Constitution for regulating procedure or the conduct of business or for maintaining order in Parliament shall be subject to the jurisdiction of any court in respect of the exercise by him of those powers. Chapter 3, Legislative Powers of the President. Power of President to promulgate ordinance during recess of Parliament. If at any time except when both houses of Parliament and if at any time except when both houses of Parliament are in session, the President is satisfied that circumstances exist which render it necessary for him to take immediate action. He may promulgate such ordinances as the circumstances appear to him to require. An ordinance promulgated under this article shall have the same force and effect as an act of Parliament, but every such ordinance shall be laid before both houses of Parliament and shall cease to operate at the expiration of 6 weeks from the re-assembly of Parliament, or if before the expiration of that period resolutions disapproving it are passed by both houses upon the passing of the second of those resolutions and may be withdrawn at any time by the President. In its explanation, where the House of Parliament are summoned to reassemble on different days, the period of 6 weeks shall be reckoned from the date of those days for the purposes of this clause. If and so far as an ordinance under this article makes any provision which Parliament would not, under this Constitution, be competent to enact, it shall be void. The Union Judiciary, Chapter 4, Establishment and Constitution of Supreme Court. There shall be a Supreme Court of India, consisting of a Chief Justice of India, and until Parliament by law prescribes a large number of not more than 7 other judges, even judge of the Supreme Court shall be appointed by the President of warrant under his hand and seal after consultation with such of the judges of the Supreme Court and of the High Court in the states as the President of may deem necessary for the purpose and shall hold office until he attained the age of 65 years. Provided that in the case of appointment of a judge other than the Chief Justice, the Chief Justice of India shall always be consulted, provided further that a judge may, by writing under his hand, addressed to the President, resign his office. A judge may be removed from his office in the manner provided in clause 4. The age of a judge of the Supreme Court shall be determined by such authority and be in such manner as Parliament may by law provide. A person shall not be qualified for appointment as a judge of the Supreme Court unless he is a citizen of India and has been for at least 5 years a judge of a high court or of two or more such courts in succession, or has been for at least 10 years an advocate of a high court or of two or more such courts in succession, or is in the opinion of the President a distinguished jurist. In its explanation 1, in this clause, High Court means a High Court which exercises or which at any time before the commencement of this Constitution exercise jurisdiction in any part of the temporary territory of India. In its explanation 2, in computing for the purpose of this clause, the period of during which a person has been an advocate any period during which a person has held judicial office not inferior to that of a district judge after he became an advocate shall be included. A judge of the Supreme Court shall not be removed from his office except by an order of the President passed after an address by each House of Parliament, supported by a majority of the total membership of that House and by a majority of not less than two-thirds of the members of that House present, and voting has been presented to the President in the same session or such removal on the ground of proved misbehavior or incapacity. Parliament may by law regulate the procedure for the presentation of an address and for the investigation and proof of the misbehavior or incapacity of a judge under clause 4. Every person appointed to be a judge of the Supreme Court shall, before he enters upon his office, make and subscribe before the President or some person appointed in that behalf by him an oath or affirmation according to the form set out for the purpose in the third schedule. No person who has held office as a judge of the Supreme Court shall plead or act in any court or before any authority within the territory of India. Salaries, etc. of judges, there shall be paid to the judges of the Supreme Court such salaries as may be determined by Parliament by law and until provision in that behalf is to so made. Such salaries as are specified in the second schedule. Every judge shall be entitled to each to such privilege and allowances and so such rights in the respect of leave of absence and pension as many as may from time to time be determined by or under law made by Parliament and until so determined to such privileges, allowances and rights as are specified in the second schedule, provided that neither the privileges nor the allowances of a judge nor his rights in respect of leave of absence or pension shall be valid to his disadvantage after his appointment. Appointment of acting Chief Justice. When the office of Chief Justice of India is vacant or when the Chief Justice is by reason of absence or otherwise unable to perform the duties of his office, the duties of the office shall be performed by such one of the other judges of the court as the President may appoint for the purpose. Appointment of ad hoc judges. If at any time there should not be a quorum of the judges of the Supreme Court available to hold or continue any session of the court, the Chief Justice of India may, with the previous consent of the President and after consultation with the Chief Justice of the High Court concerned, request in writing the attendance at the sittings of the court as an ad hoc judge for such period as may be necessary of a judge of a high court duly qualified for appointment as a judge of the Supreme Court to be designated by the Chief Justice of India. It shall be the duty of the judge who has been so designated in priority to other duties of his office to attend the sittings of the Supreme Court at the time and for the period for which his attendance is required. While so attending, he shall have all the jurisdiction, powers, and privileges and shall discharge the duties of a judge of the Supreme Court. Attendance of retired judges at sittings of the Supreme Court. Notwithstanding anything in the chapter, the Chief Justice of India may at any time, with the previous consent of the President, request any person who has held the office of a judge of the Supreme Court or of the Adult Court or who has held the office of a judge of a High Court and is duly qualified for appointment as a judge of the Supreme Court to sit and act as a judge of the Supreme Court, and every such person so requested shall, while so sitting and acting, be entitled to such allowances as the President may by order determine, and have all the jurisdiction, powers, and privileges of, but shall not otherwise be deemed to be a judge of that court, provided that nothing in this article shall be deemed to require any such person as aforesaid to sit and act as a judge of that court unless he consents so to do. Supreme Court to be a court of record. The Supreme Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. Seat of Supreme Court. The Supreme Court shall sit in Delhi or in such other place or places as the Chief Justice of India may, with the approval of the President, from time to time appoint. Original jurisdiction of the Supreme Court. Subject to the provisions of this Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any disputes between the government of India and one or more states, or between the government of India and any state, or states on one side and one or other states on the other, or between two or more states. If and insofar as the dispute is involved, if and insofar as the dispute involves any question, whether of law or fact, on which the existence or extent of a legal right depends, provided that the said jurisdiction shall not extend to a dispute arising out of any territory, out of any treaty, agreement, covenant, engagement, sanad, or other similar instrument which, having been entered into or executed before the commencement of this Constitution, continues in operation after such commencement, or which provides that the said jurisdiction shall not extend to such a dispute. Appellate jurisdiction of Supreme Court in appeals from High Court in certain cases. An appeal shall lie to the Supreme Court from any judgment, decree, or final order of a High Court in the territory of India, whether in a civil, criminal, or other proceeding, if the High Court certifies under Article 134A that the case involves a substantial question of law as to the interpretation of this Constitution, where such a certificate is given, any party in the case may appeal to the Supreme Court on the ground that any such question as aforesaid has been wrongly decided. In its explanation for the purposes of this article, the expression final order includes an order deciding an issue which if decided in favor of the appellate, in favor of the appellant, would be sufficient for the final disposal of the case. Appellate jurisdiction of Supreme Court is appeals from High Courts in regard to civil matters. An appeal shall lie to the Supreme Court from any judgment, decree, or final order in a civil proceeding of a High Court in the territory of India, if the High Court certifies under Article 134A that the case involves a substantial question of law of general importance and that in the opinion of the High Court, the said question needs to be decided by the Supreme Court. Notwithstanding anything in Article 132, any party appealing to the Supreme Court under Clause 1 may urge as one of the grounds in such appeal that a substantial question of law as to the interpretation of this Constitution has been wrongly decided. Notwithstanding anything in this article, no appeal shall, unless Parliament by law otherwise provides, lie to the Supreme Court from the judgment, decree, or final order of one judge of a High Court. Appellate jurisdiction of Supreme Court in regard to criminal matters. An appeal shall lie to the Supreme Court from any judgment, final order or sentence in a criminal proceeding of High Court in the territory of India, if the High Court had an appeal, reversed an order of acquittal of an accused person and sentenced him to death, or has withdrawn from trial before itself any case from any court subordinate to its authority, and has in such trial convicted the accused person and sentenced him to death, or certificates under Article 134A that the case is a fit one for appeal to the Supreme Court, provided that an appeal under subclause C shall lie subject to such provisions and may be made in that we have under clause 1 of the Article 145 and to such conditions as the High Court may establish or require. Parliament may by law confer on the Supreme Court any further powers to entertain and hear appeals from any judgment, final order, or sentence in a criminal proceeding of a High Court in the territory of India, subject to such conditions and limitations as may be specified in such law. Certificate for appeal to the Supreme Court. Every High Court passing or making a judgment, decree, final order, or sentence referred to in clause 1 of the Article 132 or clause 1 of the Article 133 or clause 1 of the Article 134 may, if it deemed fit so to do, on its own motion and to shall, if an oral application is made by or on behalf of the party agreed immediately after the passing or making of such judgment, decree, final order of sentence, determined as soon as may be after such passing or making, the question whether a certificate of the nature referred to in clause 1 of the Article 132 or clause 1 of the Article 133, or as the case may be, subclause C of clause 1 of Article 134 may be given in respect of that case. Jurisdiction and powers of the federal court under existing law to be exercisable by the Supreme Court until Parliament by law otherwise provides the Supreme Court shall also have jurisdiction and powers with respect to any matter to which the provisions of Article 133 and Article 134 do not apply. If jurisdiction and powers in relation to that matter were exercisable by the federal court immediately before the commencement of this constitution under any existing law, special leave to appeal by the Supreme Court. Notwithstanding anything in this chapter, the Supreme Court may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence, or order in any clause, in any cause, or matter passed or made by any court or tribunal in the territory of India. Nothing in clause 1 shall apply to any judgment, determination, sentence, or order passed or made by any court or tribunal constituted by or under any law relating to the armed forces. Review of judgments or orders by the Supreme Court, subject to the provisions of any law made by Parliament or any rules made under Article 145, the Supreme Court shall have power to review any judgment pronounced or order made by it. Enlargement of the jurisdiction of the Supreme Court. The Supreme Court shall have such further jurisdiction and powers with respect to any of the matters in the Union list as parliamentary may by law confer. The Supreme Court shall have such further jurisdiction and powers with respect to any matter as the Government of India and Government of any state may by special agreement confer if Parliament by law provides for the exercise of such jurisdiction and powers by the Supreme Court. Conferment on the Supreme Court of powers to issue certain writs. Parliament may by law confer on the Supreme Court power to issue direction, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them for any purpose other than those mentioned in clause 2 of Article 32. Transfer of certain cases where cases involving the same or substantially the same questions of law are pending before the Supreme Court and one or more high courts or before two or more high courts and the Supreme Court is satisfied on its own motion or on an application made by the Attorney General of India or by a party to any such case that such questions are substantial questions of general importance. The Supreme Court may withdraw the case or cases pending before the High Court or the High Courts and dispose of all the cases itself. Provided that the Supreme Court may, after determining the state questions of law, return any case so withdrawn together with a copy of its judgment on such questions to the High Court from which the case has been withdrawn, and the High Court shall, on receipt thereof, proceed to dispose of the case in conformity with such judgment. The Supreme Court may, if it deems it expedient, so to do for the ends of justice, transfer any case, appeal, or other proceedings pending before any High Court to any other High Court. Ancillary powers of Supreme Court. Parliament may by law make provision for conferring upon the Supreme Court such supplemental power not inconsistent with any of the provisions of this Constitution as may appear to be necessary or desirable for the purpose of enabling the court more effectively to exercise the jurisdiction conferred upon it by or under this Constitution. Law declared by Supreme Court to be binding on all courts. The law declared by the Supreme Court shall be binding on all courts within the territory of India. Enforcement of decrees and orders of Supreme Court and orders as to discovery, etc. The Supreme Court, in the exercise of its jurisdiction, may pass such decree or make such order as is necessary for doing complete justice in any case, in any cause or matter pending before it, and any decree so passed order so made shall be enforceable throughout the territory of India in such manner as may be prescribed by or under any law made by Parliament, and until provision in that behalf is so made in such manner as the President may by order prescribe. Subject to the provisions of any law made in this behalf by the Parliament, the Supreme Court shall, as respects the whole of the territory of India, have all and every power to make any order for the purpose of securing the attendance of any person. The purpose of securing the attendance of any person, the discovery or production of any document, or the investigation or punishment of any contempt of itself. Power of President to consult Supreme Court. If at any time it appears to the President that a question of law or fact has arisen, or is likely to arise which is of such a nature and of such public importance that it is expedient to obtain the opinion of the Supreme Court upon it, he may refer the question to that court for consideration, and the court may, after such hearing, as it thinks fit, report to the President its opinion thereon. The President may, notwithstanding anything in the proviso to Article 131, refer a dispute of the kind mentioned in the said proviso to the Supreme Court for opinion, and the Supreme Court shall, after such hearing, as it thinks fit, report to the President its opinion thereon. Civil and judicial authorities to act in aid of the Supreme Court. All authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. Rules of court, etc., subject to the provisions of any law made by Parliament, the Supreme Court may, from time to time, with the approval of the President, make rules for regulating generally the practice and procedure of the court, including rules as to the persons practicing before the court, rules as to the procedure for hearing appeals and other matters pertaining to appeals, including the time within which appeals to the court are to be entered. Rules as to the proceedings in the court for the enforcement of any of the rights conferred by Part 3. Rules as to the proceedings in the court under Article 139A. Rules as to entertainment of appeals under subclause C of Clause 1 of the Article 134. Rules as to the conditions subject to which any judgment, pronounced or order made by the court may be reviewed under the procedure for such review, including the time within which applications to the court for such review are to be entered. Rules as to the cost of and incidental to any proceedings in the court and as to the fees to be charged in respect of proceedings therein. Rules as to the granting of bail. Rules as to stay of proceedings. Rules providing for the summary determination of any appeal which appears to the court to be frivolous or vexatious or brought for the purpose of delay. Rules as to the procedure for inquiries referred to in clause 1 of the article 1 of the article clause 1 of the article 317. Subject to the provisions of clause 3, rules made under this article may fix the minimum number of judges who are to sit for any purpose and may provide for the powers of single judges and division courts. The minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this constitution or for the purpose of hearing any reference under Article 143 shall be filed, provided that where the courts hearing an appeal under any of the provisions of this chapter other than Article 132 consists of less than 5 judges, and in the course of the hearing of the appeal, the court is satisfied that the appeal involves a substantial question of law as to the interpretation of this constitution, the determination of which is necessary for the disposal of the appeal. Such court shall refer the question for opinion to a court constituted as required by this clause for the purpose of deciding any case involving such a question and shall on receipt of the opinion dispose of the appeal in conformity with such opinion. No judgment shall be delivered by the Supreme Court save in open court, and no report shall be made under Article 143 save in accordance with an opinion also delivered in open court. No judgment and no such opinion shall be delivered by the Supreme Court, save with the concurrence of a majority of the judges present at the hearing of the case. But nothing in this clause shall be deemed to prevent a judge who does not concur from delivering a dissenting judgment or opinion. Officers and servants and the expenses of the Supreme Court. Appointments of officers and servants of the Supreme Court shall be made by the Chief Justice of India or such other judge or officer of the court as he may direct, provided that the President may by rule require that in such cases as may be specified in the rule, no person not already attached to the court shall be appointed to any office connected with the court, save after constitution with the Union Public Service Commission. Subject to the provisions of any law made by Parliament, the conditions of service of officers and servants of the Supreme Court shall be such as may be prescribed by rules made by the Chief Justice of India or by some other judge or officer of the court authorized by the Chief Justice of India to make rules for the purpose, provided that the rules made under this clause shall, so far as they relate to salaries, allowances, leave, or pension, require the approval of the President. The administrative expenses of the Supreme Court, including all salaries, allowances, and pension payable to or in respect of the officer and servants of the court, shall be charged upon the consolidated fund of India, and any fees or other monies taken by the court shall form part of that fund. Interpretation in this chapter and in chapter 5 of part 6, reference to any substantial question of law as to the interpretation of this constitution shall be construed as including references to any substantial question of law as the interpretation of the Government of India Act 1935, including any enactment, amendment, or implementing that act, or of any order in council or order made thereunder, or of the Indian Independence Act 1947, or of any order made thereunder. Chapter 5, Controller and Auditor General of India. Controller and Auditor General of India. There shall be a controller and Auditor General of India, who shall be appointed by the President by warrant under his hand and sealed, and shall only be removed from office in like manner and on the like grounds as a judge of the Supreme Court. Every person appointed to be Controller and Auditor General of India shall, before he enters upon his office, make and subscribe before the President or some person appointed in that behalf by him an oath or affirmation according to the form set out for the purpose in the third schedule. The salary and other conditions of service of the Controller and Auditor General shall be such as many as may be determined by Parliament by law, and until they are so determined shall be specified in the second schedule. Provided that neither the salary of a Controller and Auditor General nor his rights in respect of leave of absence, pension or age of retirement shall be varied to his disadvantage after his appointment. The Controller and Auditor General shall not be eligible for further office either under the Government of India or under the Government of any state after he has ceased to hold his office. Subject to the provisions of this Constitution and of any law made by Parliament, the conditions of service of persons serving in the Indian Audit and Accounts Department, administrative powers of the Controller and Auditor General shall be such as may be prescribed by rules made by the President after consultation with the Controller and Auditor General of India. The administrative expenses of the office of the Controller and Auditor General, including all salaries, allowances, and pensions payable to or in respect of the person serving in that office, shall be charged upon the Consolidated Fund of India. Duties and powers of the Controller and Auditor General. The Controller and Auditor General shall perform such duties and exercise such powers in relation to the accounts of the Union and of the states and of any other authority or body as may be prescribed by or under any law made by Parliament, and until provision in that behalf is so made, shall perform such duties and exercise such powers in relation to the accounts of the Union and of the states as were conferred on or exercisable by the Auditor General of India immediately before the commencement of this Constitution in relation to the accounts of the Dominion of India and of the provinces respectively. Form of accounts of the Union and of the states. The accounts of the Union and of the states shall be kept in such form as the President may, on the advice of the Controller and Auditor General of India, prescribe audit reports. The reports of the Controller and Auditor General of India relating to the accounts of the Union shall be submitted to the President, who shall cause them to be read before each House of Parliament. The reports of the Controller and Auditor General of India relating to the accounts of a state shall be submitted to the Governor of the state, who shall cause them to be read before the legislature of the state. Next is part 6, the states chapter general. Definition in this part, unless the context otherwise requires, the expression state does not include the state of Jammu and Kashmir. Chapter 2, the executive, the governor. Governors of states, there shall be a governor for each state. Provided that nothing in this article shall prevent the appointment of the same person as governor for two or more states. Executive power of state, the executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him in accordance with his constitution. Nothing in this article shall be deemed to transfer to the governor any functions conferred by any existing law on any other authority or prevent parliament or the legislation of the state from conferring by law functions on any authority subordinate to the governor. Appointment of governor. The governor of a state shall be appointed by the president by warrant under his hand and seal. Term of office of governor. The governor shall hold office during the pleasure of the president. The governor may, by writing under his hand addressed to the president, resign his office. Subject to the foregoing provisions of this article, a governor shall hold office for a term of 5 years from the date on which he enters upon his office, provided that a governor shall not, withstanding the expiration of his term, continue to hold office until his successor enters upon his office. Qualifications for appointment as governor. No person shall be eligible for appointment as governor unless he is a citizen of India and has completed the age of 35 years. Condition of governor's office. The governor shall not be member of either House of Parliament or of a House of the legislation of any state specified in the first schedule, and if a member of either House of Parliament or of a House of the legislature of any such state be appointed governor, he shall be deemed to have vacated his seat in that house on the date on which he enters upon his office as governor. The governor shall not hold any other office of profit. The governor shall be entitled without payment of rent to the house to the use of his official residences and shall be also entitled to such emoluments, allowances and privileges as may be determined by parliamentary law and until provision in that behalf is so made, such emoluments, allowances and privileges as are specified in the second schedule. Where the same person is appointed as governor of two or more states, the emoluments and allowances payable to the governor shall be allocated among the states in such proportion as the president may by order determine. The emoluments and allowances of the governor shall not be diminished during his term of office. Oath or affirmation by the governor. Every governor and every person discharging the function of the governor shall, before entering upon his office, make and subscribe in the presence of the Chief Justice of the High Court exercising jurisdiction in relation to the state or in his absence, the seniormost judge of that court available, an oath or affirmation in the following form, that is to say, I, A, B, swear in the name of God or solemnly affirm that I will faithfully execute the office of governor or discharge the functions of the governor of dash name of the state, and will to the best of my ability preserve, protect and defend the constitution and the law, and that I will devote myself to the service and well-being of the people of dash name of the state. Discharge of the functions of the governor in certain contingencies. The President may make such provision as he thinks fit for the discharge of the functions of the governor of a state in any contingency not provided for in this chapter. Power of governor to grant pardons, etc., and to suspend, remit, or commute sentences in certain cases. The governor of a state shall have the power to grant pardons, reprieves, respite, or remission of punishment, or to suspend, remit, or commute the sentence of any person convicted of any offense against any law relating to a matter to which the executive power of the state extends. Extent of executive power of state subject to the provisions of this constitution. The executive power of a state shall extend to the matters with respect to which the legislature of the state has power to make laws, provided that in any matter with respect to which the legislature of the state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon this union or authorities thereof. Council of Ministers. Council of Ministers to aid and advise governor. There shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his function, excepting so far as he is by or under this constitution required to exercise his function or any of them in his discretion. If any question arises whether any matter is or is not a matter as respects which the governor is by or under this constitution required to act in his discretion, the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion. The question whether any, and if so, what advice was tendered by ministers to the governor shall not be inquired into in any court. Other provisions as to ministers. The chief minister shall be appointed by the governor, and the other ministers shall be appointed by the governor on the advice of the chief minister. And the ministers shall hold office during the pleasure of the governor, provided that in the states of Chhattisgarh, Jharkhand, Madhya Pradesh, and Odisha, there shall be a minister in the charge of tribal welfare, who may in addition be in charge of the welfare of the scheduled caste and backward classes or any other work. The total number of ministers, including the chief minister, in the council of ministers in a state shall not exceed 15% of the total number of members of the legislative assembly of that state, provided that the number of ministers, including the chief minister in a state, shall not be less than 12. Provided further that where the total number of ministers, including the chief minister in the council of ministers in any state at the commencement of the Constitution, 91st Amendment Act 2003, exceeds the said 15% or the number specified in the first proviso. As the case may be, then the total number of ministers in that state shall be brought in conformity with the provisions of this clause within 6 months from such date as the President may by public notification appoint. A member of the legislative assembly of a state or either house of the legislature of a state having legislative council belonging to any political party, who is disqualified for being a member of that house under paragraph 2 of the 10th schedule shall also be disqualified to be appointed as minister under clause 1 for duration of the period commencing from the date of his disqualification till the date on which the term of his office as such member would expire or where he contest an election to the legislative assembly of a state or either house of the legislature of a state having legislative council as the case may be before the expiry of such period till the date on which he is declared elected, whichever is earlier. The Council of Ministers shall be collectively responsible to the Legislative Assembly of the state. Before the minister enters upon his office, the governor shall administer to him the oaths of office and of secrecy according to the form set out for the purpose in the third schedule. A minister for any period of 6 consecutive months is not a member of the legislature of the state shall, at the expiration of that period, cease to be a minister. Salaries and allowances of ministers shall be such as the legislature of the state may from time to time by law determine and until the legislature of the state so determines shall be and specified in the second schedule. The Advocate General for the state, Advocate General for the state, the governor of each state shall appoint a person who is qualified to be appointed a judge of a high court to be Advocate General for the state. It shall be the duty of the Advocate General to give advice to the government of the state upon such legal matters and to perform such other duties of a legal character as may from time to time be referred or assigned to him by the governor and to discharge the functions conferred on him by or under this constitution or any other law for the time being in force. The Advocate General shall hold office during the pleasure of the governor and shall receive such remuneration as the governor may determine. Conduct of government of conduct of government business. Conduct of business of the government of a state. All executive action of the government of a state shall be expressed to be taken in the name of the governor. Orders and other instruments made and executed in the name of the governor shall be authenticated in such manner as may be specified in rules to be made by the governor, and the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the governor. The governor shall make rules for the more convenient transactions of the business of the government of the state, and for the allocation among ministers of the said business insofar as it is not business with respect to which the governor is by or under this constitution required to act in his discretion. Duties of chief minister as respects the furnishing of information to governor etc. It shall be the duty of the chief minister of each state to communicate to the governor of the state all decisions of the council of ministers relating to the administration of the affairs of the state and proposals for legislation. To furnish such information relating to the administration of the affairs of the state and proposals for legislation as the governor may call for, and if the governor so requires to submit for the consideration of the council of ministers any matter on which a decision has been taken by a minister but which has not been considered by the council. Chapter 8, the State Legislature. General Constitution of Legislature in States. For every state, there shall be a legislature which shall consist of the governor, and in the states of Andhra Pradesh, Bihar, Madhya Pradesh, Maharashtra, Tamil Nadu, and Uttar Pradesh, two houses. In other states, one house. Where there are two houses of the legislature of a state, one shall be known as the Legislative Council and the other as the Legislative Assembly. And where there is only one house, it shall be known as the Legislative Assembly. Abolition or creation of legislative councils in states. Notwithstanding anything in Article 168, Parliament may by law provide for the abolition of the legislative council of a state having such a council or for the creation of such a council in a state having no such council if the legislative assembly of the state passes a resolution to the effect by a majority of the total membership of the assembly and by a majority of not less than two-thirds of the members of the assembly present and voting. Any law referred to in clause 1 shall contain such provisions for the amendment of this constitution as may be necessary to give effect to the provisions of the law and may also contain such supplemental, incidental, and consequential provisions as Parliament may deem necessary. No such law as aforesaid shall be deemed to be an amendment of this Constitution for the purposes of Article 368. Composition of the legislative assemblies, subject to the provisions of Article 333. The legislative assembly of each state shall consist of not more than 500 and not less than 60 members chosen by direct election from territorial constituencies in the state. For the purposes of the clause 1, each state shall be divided into territorial constituencies in such manner that the ratio between the population of each constituency and the number of seats allotted to it shall, so far as practicable, be the same throughout the state. In its explanation, In this clause, the expression population means the population as ascertained at the last proceeding census of which the relevant figures have been published. Provided that the difference in this explanation to the last proceeding census of which the relevant figures have been published shall until the relevant figures for the first census taken after the year 2026 have been published be construed as a reference to the 2001 census. Upon the completion of each census, the total number of seats in the legislative assembly of each state and the division of each state into territorial constituencies shall be readjusted by such authority and in such manner as Parliament may by law determine. Provided that such readjustment shall not affect representation in the legislative assembly until the dissolution of the existing assembly. Provided further that such readjustment shall take effect from such date as the President may, by order, specify, and until such readjustment takes effect, any election to the Legislative Assembly may be held on the basis of the territorial constituencies existing before such readjustment, provided also that until the relevant figures for the first census taken after the year 2026 have been published, it shall not be necessary to readjust. The total number of seats in the Legislative Assembly of each state has been registered on the basis of the 1971 census and the division of such state into territorial constituencies as may be readjusted on the basis of the 2001 census under this clause. Composition of the Legislative Councils. The total number of members in the Legislative Council of the state having such a council shall not exceed one third of the total number of members in the Legislative Assembly of that state, provided that the total number of members in the Legislative Council of a state shall in no case be less than 40. Until Parliament by law otherwise provides, the composition of the Legislative Council of a state shall be as provided in clause 3 of the total number of members of the Legislative Council of a state. As nearly as may be, one third shall be elected by electorates consisting of members of municipalities, district, wards, and such other local authorities in the state as Parliament may by law specify. As nearly as may be, 1/12 shall be elected by electorate consisting of persons residing in the state who have been for at least 3 years graduates of any university in the territory of India or have been for at least 3 years in possession of qualification prescribed by or under any law made by Parliament as equivalent to that of a graduate of any such university. As nearly as may be, 1/12 shall be elected by electorates consisting of persons who have been for at least 3 years engaged in teaching in such educational institutions within the state, not lowering standard than that of a standard school, as may be prescribed by or under any law made by Parliament. As nearly as may be, one third shall be elected by the members of the Legislative Assembly of the state from among us persons who are not members of the Assembly. The remainder shall be nominated by the Governor in accordance with the provisions of Clause 5. The members to be elected under sub-clause A, B, and C of Clause 3 shall be chosen in such territorial constituencies as may be prescribed by or under any law made by Parliament, and the election under the said sub-clauses and under sub-clause B of the said clause shall be held in accordance with the system of proportional representation by means of the single transferable vote. The members to be nominated by governor under sub-clause E of the clause C shall consist of persons having special knowledge or practical experience in respect of such matter as the following, namely literature, science, art, cooperative movement, and social service. Duration of state legislatures. Every legislative assembly of every state, unless sooner dissolved, shall continue for 5 years from the date appointed for its first meeting and no longer at the expiration of the said period of 5 years shall operate as a dissolution of the assembly. Provided that the shared period may, while a proclamation of emergency is in operation, be extended by Parliament by law for a period not exceeding 1 year at a time and not exceeding in any case beyond a period of 6 months after the proclamation had ceased to operate. The Legislative Council of a state shall not be subject to dissolution, but as nearly as possible one third of the members thereof shall retire as soon as may be on the expiration of every second year in accordance with the provisions made in that behalf by Parliament by law. The legislative qualification for membership of the state legislature. A person shall not be qualified to be chosen to fill a seat in the legislature of a state unless he is a citizen of India and makes and subscribes before some person authorized in that behalf by election commission and oath of affirmation according to the form of set out for the purpose in the third schedule. Is in the case of a seat in the legislative assembly not less than 25 years of age, and in the case of a seat in the legislative council not less than 30 years of age, and possesses such other qualifications as may be prescribed in that behalf by or under any law made by Parliament. Sessions of the state legislature, prorogation and dissolution. The governor shall from time to time summons the house or each house of the legislature of the state to meet at such time and place as he thinks fit. But 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. The governor may, from time to time, prorogue the house or either house, dissolve the legislative assembly. Right of governor to address and send messages to the House of Houses. The governor may address the legislative assembly or, in the case of a state having a legislative council, either house of the legislative of the state or both houses assembled together and may for that purpose require the attendance of members. The governor may send messages to the house or houses of the legislature of the state, whether with respect to a bill then pending in the legislature or otherwise. A house to which any message is so sent shall with all convenient dispatch consider any matter required by the message to be taken into consideration. special address by the governor at the commencement of the first session after each general election to the Legislative Assembly, and at the commencement of the first session of each year, the governor shall address the Legislative Assembly, or in the case of a state having a legislative council, both houses assembled together and inform the legislature of the causes of its summons. Provision shall be made by the rules regulating the procedure of the House or either House for the allotment of time for discussion of the matters referred to in such address. Rights of Ministers and Advocate General as respects the Houses. Every Minister and the Advocate General for a state shall have the right to speak in and otherwise to take part in the proceedings of the Legislative Assembly of the state, or in the case of a state having a legislative session of the council, both houses, and to speak in and otherwise to take part in the proceedings of any committee of the legislature of which he may be named a member, but shall not, by virtue of this article, be entitled to vote. Officers of the state legislature, the Speaker and Deputy Speaker of the Legislative Assembly. Every legislative assembly of a state shall, as soon as may be, choose two members of the assembly to be respectively Speaker and Deputy Speaker thereof. And so often as the office of Speaker or Deputy Speaker becomes vacant, the assembly shall choose another member to be Speaker or Deputy Speaker as the case may be. Vacation and resignation of and removal from the office of Speaker and Deputy Speaker. A member holding office as Speaker or Deputy Speaker of an assembly shall vacate his office if he ceases to be member of the assembly, maybe at any time by writing under his hand addresses. if such if such member is the speaker, to the deputy speaker, and if such member is the deputy speaker, to the speaker resigns his office and may be removed from his office by a resolution of the assembly passed by a majority of all the then members of the assembly, provided that no resolution for the purpose of clause shall be moved unless at least 14 days notice has been given of the intention to move the resolution. Provided further that whenever the assembly is dissolved, the speaker shall not vacate his office until immediately before the first meeting of the assembly after the dissolution. Power of the deputy speaker or the other person to perform the duties of the office of or to act as speaker. While the office of speaker is vacant, the duties of the office shall be performed by the deputy speaker, or if the office of deputy speaker is also vacant, by such member of the assembly as the governor may appoint for the purpose. During the absence of the speaker from any sitting of the assembly, the deputy speaker, or if he is also absent, such person as may be determined by the rules of procedure of the assembly, or if no such person is present, such other person as may be determined by the assembly shall act as speaker. the speaker or the deputy speaker not to preside while a resolution for his removal from office is under consideration. At any sitting of the Legislative Assembly, while any resolution for the removal of the Speaker from his office is under consideration, the Speaker, or while any resolution for the removal of the Deputy Speaker from his office is under consideration, the Deputy Speaker shall not, though he is present, preside, and the provisions of Clause 2 of Article 180 shall apply in relation to every such sitting as they apply in relation to a sitting from which the Speaker or, as the case may be, the Deputy Speaker is absent. The Speaker shall have the right to speak in and otherwise to take part in the proceedings of the Legislative Assembly. While any resolution for his removal from office is under consideration in the Assembly and shall, notwithstanding anything in Article 189, be entitled to vote only in the first instance on such resolution or on any other matter during such proceedings, but not in the case of an equality of votes. The chairman and deputy chairman of the Legislative Council. The Legislative Council of every state having such council shall, as soon as may be, choose two members of the council to be respectively chairman and deputy chairman thereof. And so often as the office of chairman or deputy chairman becomes vacant, the council shall choose another member to be chairman or deputy chairman as the case may be, vacation and resignation of and removal from the offices of chairman and deputy chairman. A member of holding office as chairman or deputy chairman of a legislative council shall vacate his office if he ceases to be a member of the council may at any time by writing under his hand addressed if such member is the chairman to the deputy chairman and if such member is the deputy chairman to the chairman resign his office and may be removed from his office by resolution of the council passed by a majority provided that no resolution for the purpose of clause shall be moved unless at least 14 days notice has been given of the intention to move the resolution. 184 power of the deputy chairman or other person to perform the duties of the office of or to act as chairman. While the office of chairman is vacant, the duties of the office shall be performed by the deputy chairman, or if the office of deputy chairman is also vacant, by such member of the council as the governor may appoint for the purpose. During the absence of the chairman from any sitting of the council, the deputy chairman, or if he is also absent, such person as may be determined by the rules of procedure of the council, or if no such person is present, such other person as may be determined by the council shall act as chairman. Vacation and resignation. Vacation and resignation of and removal from the office of chairman and deputy chairman. A member of holding office as chairman or deputy chairman of a legislative council shall vacate his office if he ceases to be a member of the council, may at any time by writing under his hand addressed, if such member is the chairman, to the deputy chairman, and if such member is the deputy chairman, to the chairman, resign his office and may be removed from his office by a resolution of the council passed by majority of all the then members of the council, provided that no resolution for the purpose of clause salaries salaries and allowances of the speaker and deputy speaker and the chairman and deputy chairman. There shall be paid to the speaker and the deputy speaker of the legislative assembly and to the chairman and deputy chairman of the legislative council such salaries and allowances as may be respectively fixed by the legislature of the state by law and until provision in that behalf is so made, such salaries and allowances as are specified in the second schedule. Secretariat of State Legislature, the House or each House of the Legislature of a state shall have a separate secretarial staff, provided that nothing in this clause shall, in the case of legislature of a state having a legislative council, be construed as preventing the creation of post common to both houses of such legislation. The legislature of a state may by law regulate the recruitment and the condition of service of persons appointed to the secretarial staff of the house or houses of the legislature of the state until provision is made by the legislature of the state. And clause 2, the governor may, after consultation with the speaker of the legislative assembly or the chairman of the legislative council, as the case may be, make rules regulating the recruitment and the condition of service of persons appointed to the secretarial staff of the assembly of the council, and any rules so made shall have effect subject to the provisions of any law made under the said clause. Conduct business oath or affirmation by members. Every member of the Legislative Assembly or the Legislative Council of a state shall, before taking his seat, make and subscribe before the governor or some person appointed in that behalf by him an oath or affirmation according to the form set out for the purpose in the third schedule. Voting in houses, power of houses, to act notwithstanding vacancies and quorum, save as otherwise provided in this constitution. All questions at any sitting of the House of the Legislature of a state shall be determined by a majority of votes of the members present and voting, other than the Speaker or Chairman or person acting as such. The Speaker or Chairman or person acting as such shall not vote in the first instance, but shall have and exercise a casting vote in the case of an equality of votes. The House of the Legislature of a state shall have power to act notwithstanding any vacancy in the membership thereof, and any proceedings in the legislature of a state shall be valid notwithstanding that it is discovered substantially that some person who was not entitled so to do sat or voted or otherwise took part in the proceedings. until the legislature of the state by law otherwise provides the quorum to constitute a meeting of a house of the legislature of a state shall be 10 members or 1/10 of the total number of members of the house, whichever is greater. If at any time during a meeting of the legislative assembly, or the legislative council of the state there is no quorum, it shall be the duty of the speaker or chairman or person acting as such either to adjourn the house or to suspend the meeting until there is a quorum. Disqualification of members, vacation of seats, no person shall be a member of both houses of the legislature of a state, and provision shall be made by the legislature of the state by law for the vacation by a person who is chosen a member of all houses of his seat in one house or the other. I thank all my brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, officer, official, listener, learner. I thank all respected doctors and directors. I thank all honorable minister managers. I thank all adorable advocates and administrative advisors. I thank the most honorable President Modi ji. Thank you very much. Nice to see all of you. Thank you. Good evening to all of you. Thank you.